A proclamation by Her Excellency Christine Carla Kangaloo, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. Whereas it is provided by subsection 1 of section 67 of the Constitution of the Republic of Trinidad and Tobago, that each session of Parliament shall be held at such place within Trinidad and Tobago and shall commence at such time as the President may by proclamation appoint. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, do hereby appoint the Red House, Port of Spain, Trinidad, as the place at which the 5th session of the 12th Parliament of the Republic of Trinidad and Tobago shall be held, and 1:30 p.m. on Friday, the 13th day of September 2024, as the time at which the said session shall commence, with any member, if necessary, attending a sitting virtually while in Trinidad and Tobago, with the prior approval of the Speaker of the House of Representatives or the President of the Senate, in accordance with guidelines to be established. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President, St. Anne's, this 6th day of September 2024.
Shall we pray? Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Public business, government business, bills second reading.
The Minister of Finance.
Madam Speaker, I beg to move a bill entitled An Act to amend the provisions, the Prevention of Corruption Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the National Insurance Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Registration of Business Names Act, the Companies Act, the Tax Information Agreements United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Assistance, Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions, Trustees, Exchequer and Audit, the Minister of Finance and Corporation Act, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions, Registrar General, Companies, Registration of Business Names, and Non-Profit Organizations Act 2024 be now read a second time. The bill before you addresses critical elements of tax transparency and the exchange of information for tax purposes in Trinidad and Tobago. It is part of a broader legislative framework which has been recommended to us by the Global Forum Secretariat to ensure that our laws comply with international standards on tax transparency and exchange of information. Let me state at the outset that there are amendments to this bill which I intend to take at the committee stage. These amendments are as a result of additional comments provided by the European Union Anti-Money Laundering, Countering the Financing of Terrorism Global Facility in respect of clauses 11, 17, and 18. Madam Speaker, the EU Anti-Money Laundering, Counter Financing of Terrorism Global Facility is currently in Trinidad and Tobago on a mission focused on beneficial ownership over the period September the 9th to 13th, 2024. The EU team, the AML-CFT Global Facility, is an initiative aimed at supporting global efforts to combat money laundering and the financing of terrorism through technical assistance and capacity building in Trinidad and Tobago. During this mission, Global Facility representatives have been engaging with state agencies and departments responsible for anti-money laundering, countering the financing of terrorism, and the exchange of information on request. Their experts have provided valuable guidance on provisions within this bill, offering recommendations for amendments that should be adopted to enhance our legislative framework. While the proposed amendments may appear extensive, and I must confess I only got them myself last night, and I do apologize to members for the late notice, they are critical. If we do not accept the recommendations of the Global Forum EU team, we may run the risk of not being successful in the peer review process which we are currently engaged in to get off the EU blacklist and the Global Forum non-compliance list. I'm told that the amendments correct typographical errors, address omissions, and ensure consistency with broader legislative frameworks, aligning our laws with Global Forum standards. As I said, though the revisions, the amendments that I will pilot in the committee stage and which will be circulated to members shortly, they largely restate existing provisions with the required adjustments. These amendments are crucial to align Trinidad and Tobago with best practice and ensure compliance. Now, when we look at the matter at hand, the bill before us reflects Trinidad and Tobago's commitment to global standards of tax transparency. We have been given a series of deadlines and timelines to achieve our objective of coming off of the gray lists, blacklists, non-compliant lists, whatever you want to call them, by the end of this year. The bill before us was developed in consultation with and under the guidance of the Global Forum Secretariat, following the passage of the Miscellaneous Provisions Act of number 1 of 2024 earlier this year. The point of the bill before us is to remove Trinidad and Tobago from the European Union EU list of non-cooperative tax jurisdictions. This bill therefore amends 16 different pieces of legislation, ranging from the prevention of corruption to income tax, to companies, anti-terrorism, and so on. As a member of the Global Forum, Trinidad and Tobago is subject to regular peer reviews, which assess our compliance with international standards on tax transparency and exchange information. These reviews are crucial, not only for preserving our reputation on the global stage, but also for maintaining the trust of our international partners and stakeholders. This bill addresses legislative gaps that have been identified this year, 2024, in key areas such as exchange of information on request, automatic exchange of information, the Convention on Mutual Administrative Assistance in Tax Matters, the Common Reporting Standard, as well as country-by-country reporting on harmful tax practices. The amendments will empower our regulatory bodies to move effectively to exchange tax information with other jurisdictions, in line with agreements such as the Multilateral Competent Authority Agreement and the MAC, the Mutual Administrative Assistance in Tax Matters. The amendments, or the bill, introduce strict controls to prevent the misuse of tax information, protect taxpayers' rights, and ensure that the exchange of information strictly adheres to the terms of agreements to which we are bound. The bill, or the amendments that will flow from the bill, on the 16 pieces of legislation, are intended to create a favorable environment for foreign investment, strengthen our efforts to combat money laundering and terrorist financing, and ultimately contribute to economic growth. So it is designed to ensure that Trinidad and Tobago remains attractive to global investors who are compelled to comply with international standards of tax transparency and accountability. Now, the Global Forum's terms of reference set the standard for the exchange of information for the administration and enforcement of domestic tax laws. Effective exchange of information for tax purposes relies on the availability and the ability to make available reliable information that is foreseeably relevant to the tax requirements of the requesting jurisdiction in a timely manner, as well as legal mechanisms which enable the information to be obtained and exchanged. The Global Forum conducts assessments against these terms of reference, their own, which are periodically revised to reflect the latest developments in international tax transparency. In light of ongoing developments, the Global Forum Secretariat visited Trinidad and Tobago from March the 4th to March the 8th, 2024, this year, to conduct a mock on-site second-round peer review on transparency and exchange of tax information. During this review, in March of this year, the Secretariat examined our legislative changes related to tax transparency and provided recommendations that form the foundation upon which this bill was drafted. I will now go through the bill clause by clause. Clause 1, of course, the usual short title. Clause 2 is commencement, that allows elements of the bill, various sections, the whole bill, to be proclaimed at particular dates. So it will commence at particular dates when everything is ready. Clause 3 deals with the prevention of corruption. It amends Section 9 of the Prevention of Corruption Act by adding a new subsection, which provides additional criteria for when a judge is asked to authorize a police officer to enter and inspect premises to obtain a person's financial information. The amendment clarifies that if the information being sought is in the custody of the Board of Inland Revenue and was obtained under a tax information exchange agreement, the judge must first consider whether the provision of such information is permitted under the terms of that agreement. That is obviously to protect citizens. Clause 4, proceeds of crime. Clause 4 amends Section 32(6) of the Proceeds of Crime. It deletes the word "and" from paragraph 6C2, deletes the phrase "and" from paragraph 6D2, and a new paragraph E is introduced in Section 32, aligning it with the requirement added to the Prevention of Corruption Act under the proposed new subsection. This provision requires that before a judge issues an order authorizing a police officer to conduct an investigation involving access to information, the judge must first consider whether the sharing of the information is permitted under the terms of a tax information exchange agreement. Again, protection of our citizens. Clause 5. Clause 5 of the bill amends Section 24(3)(b) of the Anti-Terrorism Act by adding a new subparagraph. This deals with the power of police officers to gather information during the course of an investigation related to an offense under the Anti-Terrorism Act. Again, the new subparagraph applies to a situation where a police officer submits an application to a judge seeking authorization to gather information from specific individuals. The new subparagraph introduces similar requirements, as I have mentioned before, requiring the judge to consider whether the provision of the requested information is allowed under the terms of a tax information exchange agreement. Again, protection of our citizens. National Insurance. Clause 6 will amend Section 32 of the National Insurance Act by inserting a new subsection. This introduces a requirement for situations where a police officer applies for a warrant to obtain information, requiring a magistrate to consider whether the provision of the information being sought is allowed under the terms of a tax information exchange agreement. And only if it is allowed can the magistrate grant the warrant. Again, protecting against the misuse or unauthorized sharing of tax information. You'll see the pattern of the amendments. Financial Intelligence Unit. Clause 7 introduces a change to Section 16 of the Financial Intelligence Unit Act. Provides for the request of information by the FIUTT to listed organizations by adding a new subsection. The new addition provides that whenever a judge is asked to authorize a police officer to conduct an investigation, the judge must first check whether the sharing of any documents or information that the police might use is allowed under a tax information exchange agreement. If the agreement does not permit the use of that information, the judge should not grant the order. Again, to protect our citizens. Clause 8, Income Tax Act. Clause 8 of the bill proposes several changes to the Income Tax Act, defining terms, clarifying procedures relating to tax information exchange. Clause 8A adds a new definition for competent authority, specifically for use in a tax information exchange agreement. In Trinidad and Tobago, the competent authority would be the minister responsible for finance or his authorized representative. For other countries, the definition would align with the specifications in their tax information exchange agreement. Clause 8B updates the terminology in Section 4.8, replacing tax information sharing agreement with a tax information exchange agreement. That's just to clean up the language. It introduces a new subsection to clarify that Section 4 of the Act applies only to the specific acts listed. And another new subsection defines a tax information exchange agreement as an agreement between Trinidad and Tobago and another country to exchange financial information and supporting documents with procedures and conditions. Clause 8C modifies Section 1172 by adding the words any assessment of after the word determination. This change clarifies that the section specifically addresses the assessment process, not just the act of determination, and emphasizes its relevance to tax assessments. Clause 8D revises Section 117A to specify that the Board of Inland Revenue has the authority to determine how, in what detail, and when notices should be issued. It also adjusts the ending of the section, making it more specific to the Mutual Administrative Assistance in Tax Matters Act. Clause 9, Corporation Tax. Clause 9 amends Section 19.2 of the Corporation Tax Act to extend the application of certain sections of the Income Tax Act to the Corporation Tax Act. Specifically, it makes the following sections of the Income Tax Act applicable to the Corporation Tax Act. Section 4A, which relates to the provision of information to a foreign tax administration. Section 4B, which imposes restrictions on the use of taxpayer information. Section 4C, which establishes an offense for breaching Sections 4. Section 4, as you know, is the privacy or secrecy section of the Income Tax Act. Section 4C establishes an offense for breaching Sections 4 to 4B of the Corporation Tax Act. This means there are penalties for any unauthorized use or disclosure of taxpayer information. Section 4D, which pertains to proving information to a foreign tax administration, setting the conditions under which such information can be shared. This will align the Income Tax Act with the Corporation Tax and provide rules for handling, using, and sharing taxpayer information with foreign authorities. Clause 10, Petroleum Taxes. This clause amends Section 5.1 of the Petroleum Taxes Act to apply certain provisions from the Income Tax Act to the Petroleum Taxes Act, virtually identical to what I described before. Provision of information to a foreign tax administration, restrictions on the use of taxpayer information, penalties for violating Sections 4A and 4B, creating consequences for unauthorized use or disclosure of taxpayer information, and 4D, conditions and rules for providing information to a foreign tax administration. So this brings the Petroleum Tax Act in line with international standards on tax information and protection of taxpayers and protection of individual information. Clause 11, Companies Act, introduces a series of amendments to the Companies Act aimed at clarifying definitions, tightening regulations, enhancing compliance and enforcement. Clause 11A changes the definition of minister, replacing the reference to the minister to whom responsibility for the Registrar General's Department is assigned to the minister to whom responsibility for legal affairs is assigned. Clause 11B amends Section 33 to provide clearer procedures and regulations concerning bearer share warrants, bearer share certificates, and share warrants, including their invalidation in Trinidad and Tobago. Clause 11C modifies Section 177 by requiring companies to maintain a register of members that indicates whether each person is a nominee shareholder and includes details such as name, address, occupation, nationality, or jurisdiction of the nominator. That's very important. We need this kind of information. Far too often people hide behind dummy names, dummy companies, people fronting for them. Clause 11C, what's that? You said you did? Clause 11C also modifies subsection 6 to state that information in the register of members must be retained for 6 years after a person ceases to be a member of a company which has been dissolved. C introduces a new subsection 7, which makes it an offense for a company or its directors to fail to comply with keeping this information on its members for a period of 6 years after a company has been dissolved, and that has penalties, including fines and imprisonment. Clause 11D clarifies the registration requirements in Section 195.4, we're talking Companies Act here, by specifying that registration must be done with the registrar under Section 33. Clause 11E amends Section 199 to replace register as with record, and specifies that this information must be maintained in the register maintained by the company for that purpose. Clause 11F modifies Section 3082, requiring applicants to complete the prescribed form and pay the prescribed fee as outlined in Section 5 of the Non-Profit Organization Act. Clause 11G revises 3181 of the Companies Act to replace paragraphs N and O and require more detailed information in a statement filed by an external company. That's another area where people hide, because if you are an external company, or in the past, the registration requirements and identification requirements for external companies is far less than for local companies. Clause 11H, so this now requires much more detailed information from external companies. Clause 11H introduces a new section 328. Just let me give an example. There are some external companies in Trinidad that file that they're owned by a trust somewhere else. So you don't know who the owner is. Okay? That has to stop. Clause 11H introduces a new section 328 to address defaults by external companies that fail to submit any required return notice, document, or fee to the registrar. Clause 11I, and of course there will be penalties and so on. Clause 11I amends Section 337A to provide that Sections 337B and 337E should be interpreted as an international organization, even if composed of countries or governments and were considered an individual under the law. Clause 11J enhances Section 483 to give the registrar authority to identify inconsistencies or inaccuracies in documents and require the company to correct them within 30 days. Clause 11K amends Section 489 of the Companies Act to add a new paragraph allowing the registrar to strike a company off the register if there is reason to believe that any information provided in applications or documents is misleading, false, or deceptive in a material way. As one can see, Madam Speaker, these amendments are designed to enhance transparency and accountability by clarifying the role, tightening regulations on company information, increasing penalties for non-compliance, and empowering the registrar to correct inaccuracies. This will mean that companies will now be held to higher standards of governance and compliance. Clause 12, Registration of Business Names Act. How much more time do I have, Madam Speaker?
Time expires at 2:19.
Okay, thank you. Registration of Business Names Act. Clause 12 of the bill introduces several changes to the Registration of Business Names Act, strengthens the registration requirements for businesses, increases penalties for non-compliance, and provides clearer guidelines for addressing default. Clause 12A repeals and replaces Section 3 of the Act, establishing that all firms must be registered in accordance with the provisions of the Act to legally conduct business. One would think that should have been the case so long ago. This clause also specifies that firms that began operating before the new Section 31A must comply with the registration requirement within 3 months. Clause 12B repeals Section 7 of the Act. This suggests a removal of outdated or redundant provisions. Clause 12C increases the penalty for failure to register a business. This penalty is raised from a daily fine of $200 to a one-time fine of $10,000 with an additional fine of $300 for each day the offense continues. This change is designed to enforce compliance with registration requirements. There are far too many people operating outside of the law. Clause 12D introduces 2 new sections, 9A and 9B. 9A introduces a new penalty for the late submission of documents to the Registrar General, with a fine of $300 for every month or part thereof that the documents are overdue. Section 9B allows for the suspension of a firm's registration if it fails without reasonable cause to submit any retired return, notice, document, or fees to the Registrar General as required. It also allows the business to remedy the default, allowing for the registration to be reinstated once the issue is resolved. This aims to reinforce the importance of firms maintaining accurate, up-to-date business records, ensuring that all firms operating in Trinidad and Tobago are properly registered. 13, Tax Information Exchange Agreements, United States of America Act. This clause amends sections 5 and 9(1) of the Tax Information Exchange Agreements, U.S. Act of 2017. It focuses on updating the term competent authority and aligning it with the specific terms of each tax information exchange agreement. The competent authority will be the Minister of Finance or his authorized representative in Trinidad and Tobago, and what is defined in the tax information exchange agreement for other countries. It ensures the correct government official is identified for handling matters relating to the exchange of tax information. Non-Profit Organization Act. Clause 14 of the bill speaks to the amendments to the Non-Profit Organization Act of 2019 to enhance compliance and clarify procedures for non-profit organizations. It repeals Section 7, Renewal of Registration, and 12.2, Appeals for Renewal of Registration, and modifies the language in Section 16 to specify that if a controller of a non-profit organization fails to notify the Registrar General or submit any documents within the specified time, the Registrar General is authorized to impose a penalty of $300 per month. A new subsection is also added to Section 21 of the Non-Profit Organizations Act, granting the Attorney General the authority to apply to the High Court for an order of forfeiture against the property of a non-profit organization. This action is permitted when the non-profit organization has failed to apply for restoration to the Registrar General under Section 21D, which outlines the procedure for reinstating a non-profit that has been deregistered. 14 is all about strengthening the regulatory framework for non-profit organizations in Trinidad and Tobago. It aims to ensure compliance by increasing the accountability of controllers, persons who are in charge of a non-profit organization, to notify the Registrar General and submit required documents within the required periods. It also established penalties for delays and non-compliance. It provides a mechanism for the Attorney General to seek forfeiture of a non-profit organization's property if it fails to apply for restoration after it has been deregistered. This reduces the risk of money laundering, terrorist financing, and aligns with the FATF recommendation 8. It strengthens Trinidad and Tobago's compliance with international standards and addresses the misuse, this is a real thing, of non-profit organizations for terrorist financing. 15. Clause 15 of the bill amends the Tax Information Exchange Agreements Act of 2020 by redefining the competent authority as I discussed before. Clause 16, Mutual Administrative Assistance in Tax Matters Act. It amends the Mutual Administrative Assistance in Tax Matters Act, again by updating the definition of competent authority, again as I described before. Clause 17 addresses the miscellaneous provisions, trustees, exchequer and audit, the Minister of Finance, Incorporation Act, proceeds of crime, income tax, partnerships, securities, tax information, exchange agreements, non-profit organizations, and mutual administrative assistance in Tax Matters Act. It introduces a number of amendments, extensive, to multiple pieces of legislation that were previously amended by the Miscellaneous Provisions Act of 2024. The trustee ordinance is amended to provide a more comprehensive definition of beneficial owner, including specific details for various entities such as trusts and legal persons. The amendment also extends the application of Part 2 of the trustees ordinance, which pertains to investments, to trusts governed by Trinidad and Tobago laws, as well as those not governed by these laws, but administered by a trustee residing in Trinidad and Tobago. It requires trustees to identify and verify beneficial owners, maintain records, report any non-compliance. Again, it is a practice of persons who wish to avoid detection that they use trusts and they hide behind these trusts, so that this amendment is designed to penetrate the veil of secrecy relating to trusts. It's designed to allow disclosure of who really owns a trust, who's the beneficial owner. Okay? Also, the Exchequer and Audit Act is amended to clarify specific wording regarding financial interests. Amendments are also made to the Minister of Finance Incorporation Act, which refine definitions related to beneficial ownership, etc. The financial obligations regulations have been amended to ensure that the definition of beneficial owner is consistent with the definitions provided in the Companies Act and the Trustees Ordinance. The Companies Act has been amended to collect references and mandate external companies to provide details about bearer shares. Provisions regarding beneficial ownership have also been amended for consistency and accuracy. For those who may not know, a bearer share is just a piece of paper that has a value. It has no name. It has no owner. Somebody could give it to you. Some criminal could give it to you. And you just come and present it, and it has monetary value. Thanks. The Partnerships Act is amended to introduce new sections defining key terms, outlining obligations for identifying and verifying beneficial owners. Securities Act is amended same way to expand the definition of beneficial owner, require justification for ownership status, and allows for regular verification of beneficial ownership. The Non-Profit Organization Act is also amended to define beneficial ownership within the non-profit sector, mandating the filing of returns and penalties for non-compliance. The Tax Information Exchange Agreements Act 2020 is amended to provide updated definitions to include international agreements with the United States and so on. And finally, this clause amends the Mutual Administrative Assistance in Tax Matters Act 2020 to revise definitions and timeframes for compliance, and so on. Impose penalties for false self-certification and set new reporting requirements for financial institutions. This clause 17 makes comprehensive changes across multiple pieces of legislation to enhance transparency, compliance, and regulatory oversight in Trinidad and Tobago. It strengthens the rules on identifying beneficial owners and increases reporting obligations. Clause 18 deals with the miscellaneous provisions, Registrar General, Companies, Registration of Business Names, Non-Profit Organization Act. It introduces various amendments. It deals with terminology. It changes the word revision to reversion. It adds a new section empowering the Registrar General to inspect registers, books, accounts, and documents of relevant persons, such as companies, firms, trusts, non-profit, and so on. That is amendments to the Registrar General's Act. It amends the Companies Act to update the definition of authorized corporate service provider and require companies to have agreements specifying shares or membership interests issued to shareholders, again, dealing with beneficial ownership. It amends Section 9 of the Companies Act to add requirements for verifying information and agreements and sets new formalities for company incorporation. It also amends Section 33 of the Companies Act to change the timing for issuing shares or membership interests to at the time of incorporation, rather than within 30 days, and adjust the deadline for previously incorporated companies to comply within 3 months. And those of you who know anything about the company's registry, you will see, if you go on it, you'll see companies, some of them don't issue shares at all. Who's the owner? So one has to deal with these things. Clause 18B V replaces Section 329(1) to update the process for filing a notice of cessation for an external company. It expands the definition of beneficial owner, 18B VI, to include reporting entities under the Securities Act. 18B VII amends Section 337B to provide detailed requirements for issuing notices and keeping registers of beneficial ownership. 18B VIII modifies Section 337C to define the timeline for identifying beneficial owners. And 18BIX enables the registrar to maintain a register of beneficial owners. The Registration of Business Names Act is also amended to specify the required information for registering a firm. The Non-Profit Organizations Act, again, the amendments clarify the required information for registration and allow rules to be printed or electronically affixed. Clause 18 of the bill makes corrections, clarifies definitions, updates registration requirements, and strengthens compliance. Now, Madam Speaker, The government has made significant strides over the years in enhancing tax transparency. We have strengthened tax governance, improved information exchange, addressed harmful practices. In all of this, we are guided by the Global Forum and the OECD. We are committed to these reforms, and we continue to actively engage with the EU to ensure a fair and compliant tax environment. We are also focusing on building the capacity of our technical staff to support this legislative agenda. Because even though we may amend all of these laws, unless the persons in the Board of Inland Revenue and the Registrar General's office do the work they are supposed to do to deal with beneficial ownership, to strike off non-compliant or inactive companies, to exchange information, then all of this will come to naught. In so doing, the Ministry of Finance recently participated in a seminar organized by the Economic and Financial Police Academy in Ostia, Italy, and the Secretariat of the Global Forum on Transparency and Exchange of Information. This seminar, hosted by Italy, focused on beneficial ownership and exchange of information assessor training to prepare Trinidad and Tobago for the peer review process we are undergoing now. Additionally, the Ministry of Finance represented Trinidad and Tobago at the United Nations Economic and Social Council 2024 special meeting on international cooperation in tax matters at the UN in New York in March of this year. During these sessions, the staff in the Ministry of Finance established very important contact with key representatives of the Global Forum and the Council of the European Union. Following that, I wish to inform this Honourable House that on 3rd of July, I wrote to the Chair of the Code of Conduct Group of the European Council outlining the extensive efforts we have undertaken and reaffirming our commitment to meeting the necessary requirements for Trinidad and Tobago's removal from the list of non-cooperative tax jurisdictions. So we keep pushing this, Madam Speaker, and the end of this year is our goal to be removed from the various lists with the Global Forum and the EU. We maintain continuous dialogue with them and with the OECD to address all matters related to our inclusion on the EU's list of non-cooperative tax jurisdictions. And when we come to the amendments, I was contacted by the Registrar General's office a few days ago, and I was informed that there was a team out of Europe looking at our Registrar General's office, and they had recommended amendments. I was asked whether I would be inclined to propose these amendments today, and even though I know they're late, and even though I know they're voluminous, I thought it would be irresponsible of me not to present the amendments that arose from that visit, which took place between the 9th and 13th today of September. It would have been irresponsible of me, knowing that a team had visited the Registrar General's office in Trinidad and Tobago for the specific purpose of looking at our laws and determining how compliant we are, not to bring these. I am simply explaining why these amendments have come at short notice. So, Madam Speaker, I am satisfied we've developed a robust and flexible strategy to address Trinidad and Tobago's inclusion, to deal with the removal of Trinidad and Tobago's inclusion on the European list of non-cooperative jurisdictions for tax purposes. I'm satisfied that we have established a very strong working relationship with the Global Forum and the OECD. I am satisfied that the relationship is such that as we continue to move, I expect to be able to sign the treaty dealing with the mutual assistance in administrative matters, as administrative assistance in tax matters, within the next couple of months, which will be a major step moving us towards compliance and getting us off the various grey lists and black lists. So, Madam Speaker, this bill is absolutely essential. The amendments are absolutely essential. And I would ask members, let us work together and let us remove ourselves from these grey lists and blacklists so that Trinidad will become compliant and become a destination that does not have this stigma and would not be affected, our foreign investment would not be affected. I thank you, Madam Speaker.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Prevention of Corruption Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the National Insurance Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Registration of Business Names Act, the Companies Act, the Tax Information Agreements, United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions, Trustees, Exchequer and Audit, the Minister of Finance Incorporation Act, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations, and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions, Registrar General, Companies, Registration of Business Names, and Non-Profit Organizations Act 2024 be now read a second time. Member for Barataria, Samuel.
Thank you very much, Madam Speaker, for recognizing me to join this debate. And I welcome back all my colleagues on this first sitting of the last session of this 12th Parliament. Some of us will be here after, and some of us may not be here after this session has ended. And Madam Speaker, I'm being disturbed by my colleagues next door. Madam Speaker, before us is a quite voluminous piece of legislation which we often deem to be an omnibus bill. And very rarely in these omnibus bills you will have one piece of legislation amending several pieces of other legislation. And this is a rare occasion where one omnibus bill is now amending two other omnibus bills. And it's a very convoluted manner in which bills are being brought to this Parliament, because there are two miscellaneous provisions bill that this miscellaneous bill is amending. So, Madam Speaker, it's quite a voluminous piece of legislation which touches and concerns our compliance when it comes to our obligations and our international obligations as it relates to Global Forum, OECD. We have passed several pieces of legislation in this Parliament before to take us out of the grey list for FATF, the Financial Action Task Force, and the Caribbean Financial Action Task Force. But somehow this Global Forum matter, Madam Speaker, has been troubling us for quite some time. Even when I was a member in the other place, that's in the 11th Parliament, Trinidad and Tobago was placed on what is called the blacklist by the OECD, the Global Forum. And we were placed on that blacklist because we were largely non-compliant. We have certain obligations when we are members of the Global Forum, where, as a state, as a country, Trinidad and Tobago is required to exchange taxpayers' information. And there are various methods in which this is exchanged for tax transparency. There's automatic exchange where there's an anniversary date. There's spontaneous exchange, and then there's exchange by request. So in this particular piece of legislation, Madam Speaker, we have passed several other legislation that we are now amending to try to become compliant. You would remember there was a particular Joint Select Committee where 3 bills were committed to that Joint Select Committee, which we are also dealing with here today. The Income Tax Amendment Bill, the Mutual Administrative Assistance in Tax Matters, and the Tax Information Exchange Agreement Bill. And Madam Speaker, we had warned the government that you needed to pass this legislation in order to come out of the blacklist. We told them that, We told them, at several occasions, you need to pass these legislation all in one. But what did they do? They pull out one bill from the JSC of 3 and try to pass one to tell Global Forum, hey, look, we're doing something, we're trying to become compliant. And we told them that was a lazy approach to take, pass the 3 bills together. But this exercise with the Global Forum to become compliant is just not about passing legislation. And the minister said it. He said if the BIR or the Registrar General does not do their part, then we will remain on the blacklist. Simply because when we go through peer evaluation, they look at 2 things. They look at the legal and regulatory framework, and then they look at the implementation of the framework. And this is where the government has always fallen down. They pass legislation, but they simply cannot implement it. This government served 2 terms, Madam Speaker, and they cannot take us out from the blacklist. They cannot. It will take a UNC government to take Trinidad and Tobago off the blacklist. It will take a UNC government to do that. It will take a UNC government. Madam Speaker, later this year, Trinidad and Tobago will undergo a second round of evaluation for 2024 to examine our legal framework, which we have in place, to determine whether or not we are going to become compliant. And Madam Speaker, several times we told the government, listen, you need to pass this legislation in a holistic manner. We were warned that if Trinidad and Tobago remains on the blacklist, I want to remind people in this country, Trinidad and Tobago, that we were warned, Madam Speaker, when we just came onto the blacklist, that this is FATCA on steroids. I have a Newsday article, Madam Speaker, dated the 28th of October 2017, where Trinidad and Tobago was under fire, because if we remain on this blacklist, what will happen is that we will lose correspondent banking with international institutions. Madam Speaker, we have been on the blacklist since 2017. We are now in 2024. We are in 2024. And this blame lies solely on the feet of the government with having us on this blacklist. They can jump high and they can jump low and they can try to blame the opposition. We supported the legislation and the parliamentary record is there. They will come with their narrative that we try not to support this legislation. That is false. We gave the government the assistance, we gave them amendments, and we gave them the support to pass the legal framework, Madam Speaker. They have not implemented a single thing. A single thing. They have not implemented a single thing. Imagine other Caribbean territories, our neighbors, have been able to come out of the blacklist years ago. Barbados came out in 2021, Madam Speaker, save and except for Antigua and Barbuda, who remains on the blacklist with us. The other Caribbean territories have been removed from the blacklist because they have governments that work, Madam Speaker. Look, I have a press release here dated the 20th of February 2024, which gives the 12 jurisdictions that are currently on the blacklist after the others have been removed. It goes firstly, Madam Speaker, with American Samoa, Anguilla, Antigua and Barbuda, Fiji, Guam, Palau, Panama, Russia, Samoa, Trinidad and Tobago, U.S. Virgin Islands, and Vanuatu. They are on the list with us. Those are the 12 jurisdictions on the list. There are other countries that have been removed, and we somehow remain in this dozen, Madam Speaker. Madam Speaker, we on this side wish that we could come out of the blacklist. This is an international embarrassment that the government has had us on since 2017. Every time this matter comes up, Madam Speaker, in the Council of the European Union, Trinidad and Tobago cannot be removed from that blacklist. They cannot. Look, I have in my hand, Madam Speaker, the outcome of the proceedings. It's like the minutes of the Council of the European Union, dated 5th December 2017 from Brussels. And it says, the EU list of non-cooperative jurisdictions for tax purposes, Council conclusion. And when you turn to page 11 of this document, it says Trinidad and Tobago has been attributed a rating of non-compliant by the Global Forum on Transparency and Exchange of Information for tax purposes, has not signed and ratified the OECD Multilateral Convention on Mutual Administrative Assistance in Tax Matters, has a harmful preferential tax regime, and did not commit to addressing these issues by the 31st of December 2018. Trinidad and Tobago's commitment to comply with criteria 1.1 and 3 will be monitored. 2017. Madam Speaker, in 2017, something happened. We received a letter, and I have the letter in my hand. A letter from Brussels again, the 23rd of October 2017, and I hope I get the person's name right, Fabrizia Lapacorella, and this person is from the Global Forum, writing to the Permanent Secretary, the Ministry of Finance, and identifying to us, Madam Speaker, that we now have to comply because they were warning us that we will be placed on this particular blacklist or we will be deemed to be non-compliant. What it says is that the Code of Conduct will not recommend to the Council of the EU to include in its list of non-cooperative jurisdictions for tax purposes any country or jurisdiction which commit to correct the identified deficiencies by 31 December 2018 at the latest. To this end, the Code of Conduct Group would appreciate receiving a precise timeline and a description of the steps for the implementation of the changes by the date indicated below. And the individual asked, Madam Speaker, that the government respond by the 17th of November 2017. Remember that date? And it indicated that we have to apply our automatic exchange of information, that we have to sign the treaty, but before we sign the treaty, we must have the framework in place incorporated into domestic law. Madam Speaker, the person asked the minister to respond by the 17th of November. The minister did not respond by the 17th of November. The minister decided to respond on the 21st of November 2017 now, Madam Speaker, and indicated that the government is reviewing the laws, again, promises after promises, and then they gave a timeline that they're going to pass the bills, some of which we are dealing with now, to become compliant. The minister indicated that they will pass the income tax bill by June 2018. We did that one. The double taxation treaty by 2018. The Companies Amendment Bill 2017. Then the Mutual Administrative Assistance in Tax Matters Bill, Madam Speaker, he indicated to the EU that they will pass this bill on the 30th of November 2018. Madam Speaker, you know when we passed that bill? That bill was Act 2 of 2024. Madam Speaker, 2020. Madam Speaker, when he asked about the BEPS inclusive framework legislation, he said we'll pass that by the 30th of June 2019. That is Act 2 of 2024, and it's not proclaimed.
Where's the Minister of Finance?
Madam Speaker, they passed over 90 bills since this letter was sent, and they did not engage passing legislation to take us out of the blacklist. That is shameful, Madam Speaker. That is embarrassing. The evidence is before us. The government has placed Trinidad and Tobago in this internationally embarrassing position. You're telling me since 2017 to 2024, you could not pass the legislation, implement the framework to take us out of this blacklist, Madam Speaker? Look, in 2023, Madam Speaker, on the 6th of February 2023, again, the Council of the European Union, their notes, their minutes are online, and I pulled a copy of it. And at page 8 of that meeting, Madam Speaker, they said the entry of Trinidad and Tobago in Annex 1 should be updated by including a reference to Criterion 1.1 to reflect its commitment at a high political level made by letter dated the 17th of November 2022. I do have a copy of that one. As regards addressing the Global Forum determinations on the implementation of the required domestic and international legal framework for automatic exchange of information. So another letter was sent in 2022 to the Global Forum, the Code of Conduct Group, telling them that we'll address these deficiencies. Madam Speaker, 2 years later, we now find ourselves in Parliament at the last session to try to deal with this particular matter. At the last session. And the last outcome of proceedings, which is dated the 20th of February 2024, this is the latest rating from the Council, when it examined Trinidad and Tobago, which we're dealing with today, Madam Speaker, this is what it says, February 2024. Trinidad and Tobago does not have a rating of at least largely compliant by the Global Forum for Exchange of Information and Requests, has not signed and ratified the OECD Multilateral Convention on Mutual Administrative Assistance as amended, has harmful preferential tax regimes, free zones, does not implement the BEPS minimum standard on country-by-country reporting, and has not resolved these issues yet. Trinidad and Tobago has also committed to addressing the Global Forum recommendations with regards to automatic exchange of information in due time, so as to achieve determination of at least in place but needs improvement. Madam Speaker, this is what Trinidad and Tobago is trying to do. This is in quotations here. We are trying to achieve in place but needs improvement. That is trying to get a bare pass, Madam Speaker, on core requirements 1 and 2 in the Global Forum peer review report in the autumn of 2024. So they are trying to get a bare pass at the end of 2024, Madam Speaker. They are trying to get a bare pass when they had over 7 years, Madam Speaker, to deal with this matter and take us out of the blacklist. But they have not done so. They have not done so. And we on this side believe that they don't have the competency to take us out of that blacklist, Madam Speaker. They simply don't have it. They don't have it. Now, Madam Speaker, getting into the particular provisions of the legislation, when you look at particular clauses in the bill, where we look at the amendments to the Prevention of Corruption Act, it now allows the DPP, when making applications for orders under the Prevention of Corruption Act and police officers under the Proceeds of Crime Act, Madam Speaker, to now include the fact that information can be requested for taxpayers' information that would be governed under these particular treaties that we have. Because the multilateral treaties operate in such a way that it's a global environment. So once the parties to that convention sign on to it, Trinidad and Tobago can request information from any jurisdiction within the Global Forum, and that jurisdiction can request information from us once we are part of that multilateral treaty. So it makes the sharing of information easier with respect to taxpayers' information. When you look, Madam Speaker, at particular amendments to this bill, one that troubled me the most has to be this, because there's now an amendment to the FATCA legislation, which we call, the proper name for it will be the Tax Information Agreements United States of America Act. And this matter, Madam Speaker, troubled Trinidad and Tobago significantly, because the United States of America is different from the Global Forum in this aspect, because they required us to enter into single agreements with the US because their reporting requirements are a bit more stringent. So that is why FATCA was passed in order for information to be shared easier, quicker, and more efficient between Trinidad and Tobago and the US. Hence, there's a particular and singular bill just to deal with the United States. The other countries will now be part of the OECD Multilateral Convention, where everybody is at the table. So this bill now amends that FATCA legislation. And that troubled me, Madam Speaker, and I'll tell you why it troubled me at Clause 15. And I'll give a briefing of what the amendment says. It says here, it's Clause 13. The Tax Information Exchange Agreements United States of America Act 2017 is amended in sections 5 and 9(1) by deleting the definition of competent authority and substituting the following new definition. Competent authority in relation to tax information exchange agreement means, in the case of Trinidad and Tobago, the minister to whom responsibility for finance is assigned or his authorized representative. Now, I listened to the minister and he glossed over the amendment. He just read the amendment into the record, but did not give a reason for changing the competent authority. Now, Madam Speaker, you would remember, the bill is clear. The competent authority that deals with the United States of America is the Board of Inland Revenue, which is set up under Section 3 of the Income Tax Act. Look, when we were dealing with this matter back then in 2017, there was a fight between the opposition and the government because we believed that the minister should not insert himself with being privy to taxpayers' information. This bill was then committed to a joint select committee. Madam Speaker, I have the Hansard record here, dated the 13th of February 2017, when that JSC report was dealing with this identical issue of competent authority. And I want to read what the minister said. The Minister of Finance said, Clause 5, 6, 7, and 8 are all clauses in Part 2 of the amended bill and deal with certain articles found in the 1989 agreement between Trinidad and Tobago and the United States. Clause 5 defines certain words and phrases used in that part. A particular note, Madam Speaker, and this is an important request made by the opposition, which we agreed to the definition of competent authority, now means the Board of Inland Revenue established by Section 3 of the Income Tax Act. You may recall, Madam Speaker, that in the original bill, the minister was defined as a competent authority, and in the original Clause 6, the minister was empowered to authorize any person to give effect to any declared agreement. Madam Speaker, this change was also agreed to by members of the Joint Select Committee, and in the amended bill is now abundantly clear that only the Board of Inland Revenue is the competent authority for the purposes of the bill. So in 2017, you agreed after that Joint Select Committee to remove the minister as the competent authority and insert the Board of Inland Revenue, and now surreptitiously you go back on that particular position, Madam Speaker, and place the minister as the competent authority. Madam Speaker, I don't know if dishonest is an unparliamentary word, but this is what it is, Madam Speaker.
So, member, I think you answered your own question. So I stood up, it's unparliamentary. I'll ask you to withdraw it.
Madam Speaker, I'll withdraw that particular word, Madam Speaker. But the facts speak for themselves. The facts speak for themselves. You cannot, on one hand, allow the opposition and other members of the Joint Select Committee to put a position on the table. You agree to the position, and now you come with an omnibus piece of legislation to reverse that. Madam Speaker, you know what the danger in this is? The danger in this is that the competent authority is the authority which is used as the conduit between the both countries, the requesting state and the requested state. The minister, if you look at the parent legislation, the FATCA legislation, has serious powers under that legislation, Madam Speaker, serious powers. The competent authority at Section 7 of that FATCA bill shall exchange information with the Secretary of the Treasury in order to administer and enforce any law concerning the taxes referred to in Section 6. It shall, on the receipt of a request for information, provide the information so requested. So if you have to provide the information, Madam Speaker, that means the minister will be privy to taxpayers' information. That is the danger of this thing. So he can request information and also see information that is requested. Madam Speaker, this is the danger in this bill, Madam Speaker. How can we allow this? This means any person, minister sitting as competent authority under these tax exchange agreements, can request information. Why? Why did you go back behind your word and now change this? Why? You didn't tell us. You didn't give us a rationale. It just found itself in the bill. And Madam Speaker, we passed also a piece of legislation that we are now amending here at clause 15, which deals with the Tax Information Exchange Agreements Act 2020, which is the enabling legislation to incorporate these agreements into the domestic law, because we have to incorporate our international treaties in domestic law for them to become effective. There are some jurisdictions, as soon as you sign the treaty, it becomes part of the domestic law. But in Trinidad and Tobago, we have to incorporate it within our domestic regime. Madam Speaker, do you know the minister did the exact same thing with the Tax Information Exchange Agreement, replaced the Board of Inland Revenue with the minister. So now the minister is in charge of requesting and dealing with requested information. And this is not regular information, you know. This deals with your taxpayers' information. Why are you putting taxpayers' information in the hands of a politician? Yeah. That is dangerous. What if the US or any other jurisdiction wants information on the sitting Minister of Finance? What happens there? Is he going to say, I'm not going to give the information? That is why you must entrust these heavy responsibilities that deal with confidentiality and sensitive information in the hands of independent institutions. In the hands of independent institutions, not a politician. This is dangerous dangerous business that we're engaged in here, Madam Speaker. And the thing is, I don't want the government or the minister, anybody, responds afterwards to come and say, well, that is a recommendation of the OECD, that they want the minister to become the competent authority. Because I went and checked other jurisdictions who are the competent authority. I looked at Canada, who is compliant. Canada uses, Madam Speaker, their Director of Competent Authority Services, and that also falls within their structure of what we call the revenue collection or revenue authorities. Barbados, who came out of the blacklist long time, they, if you look at their competent authority, Madam Speaker, is a Mr. Stout from Global Relations Unit, Barbados Revenue Authority. They are compliant. When you look at Dominica, Dominica looks at the Comptroller of the Inland Revenue Division. Madam Speaker, when you look at Jamaica, the Commissioner General Tax Administration, Jamaica, Madam Speaker, which is basically their tax collection, their revenue authority, Madam Speaker, or the equivalent to the BIR. None of those countries name their Minister of Finance. So why does Minister of Finance want to be the competent authority? Madam Speaker, the minister must withdraw these amendments. We have no difficulty, Madam Speaker, we have no difficulty on this side with allowing the Board of Inland Revenue to be the competent authority. What is the issue with the Board of Inland Revenue becoming the competent authority? Why are you chopping away at the powers and the independence of the Board of Inland Revenue, vesting these large powers under the hands of a politician to deal with sensitive taxpayers' information? Madam Speaker, I am not casting any aspersion on any minister in this House, but this minister seldom, he often falls out with a lot of people in this country. You know. He has Ms. Jayawanti Ramdas suing him on one side. I think Ms. Rohini Ramkisoon on another side. Now I see Ms. Beverly Khan, is the procurement regulator, has an adverse report, Madam Speaker. So that is why you must not entrust these powers in the hands of politicians. Give it to the BIR. Give it to the BIR. There is no justification, Madam Speaker, in this. There can be no justification why the minister should sit as the competent authority. If he says the OECD says that we must do this, he must give us the evidence of that. Give us the evidence of that. Because we were very compliant with the US, with FATCA, when we put the BIR as the competent authority. We never get blacklisted by the US for that. We might get blacklisted because of the relations with Venezuela, but not because of FATCA. Madam Speaker. So these are the reasons, Madam Speaker, that we have to raise concerns. The other amendments deal with really regulatory frameworks in terms of the company's registry amendment to file further forms to disclose the members of the company, members of the non-profit organizations. We have amendments to deal with the Anti-Terrorism Act. Madam Speaker, those may be fine. But you see, when it comes to this removal of the competent authority from the Board of Inland Revenue to the minister, we have fundamental differences, and we will depart on that particular point. We have other amendments here, and this is the difficulty when you deal with omnibus bills. You may agree with certain clauses, but there are others that will be adverse and we cannot support, Madam Speaker. And that's the simple answer to these matters. But we are suggesting on this side that, Madam Speaker, if the minister really wants to get serious, remove this amendment with the minister and leave the Board of Inland Revenue. Leave it. Even in 1989, legislation that dealt with the agreements between Trinidad and Tobago and the US had the BIR as the competent authority and not the minister, a point which he acknowledged, the minister, acknowledged in that debate when we dealt with FATCA in 2017. So there can be no justification, as I said, Madam Speaker, with respect to the competent authority. The other jurisdictions, as I said earlier on, also have their inland revenue divisions, their revenue authority that deals with these matters, because these are serious issues. We, at the end of the day, Madam Speaker...
Honourable Member, you have 2 minutes left of ordinary speaking time. You're entitled to 15 additional minutes to wind up your presentation if you wish to avail yourself of it.
Madam Speaker, I think I will wind up in the next 2 minutes because I am very anxious to hear how this government is going to defend this particular matter, Madam Speaker. I'm anxious. And in these final words, Madam Speaker, I want to say that the government must withdraw this amendment that deals with the competent authority. Madam Speaker, they must withdraw it. And it will take, as I said before, a UNC government to take us out of the blacklist. And I thank you very much.
The Attorney General.
Thank you. Thank you very much, Madam Speaker. And may I take the opportunity to acknowledge all members back here to work in the nation's interests and to maintain the appropriate decorum and quality of our contributions in the interest of all of Trinidad and Tobago. Thank you for the opportunity, Madam Speaker, to speak on this important bill, and a bill which seeks to amend 16 pieces of legislation. And my task has been made relatively easy and lightened considerably by the very comprehensive pilot of the Honourable Minister of Finance, who has already underscored the importance of this bill and its eventual passage into law, all of whose contribution I endorse and shall not repeat. Madam Speaker, a fundamental aspect of this bill is to address the charges and concepts that our laws do not facilitate the efficient and timely exchange of information for tax purposes with other jurisdictions, that our information is inadequate and unreliable, that our tax information landscape is not sufficiently transparent. And what we are about here with this bill, this omnibus bill, in a work in progress with the Global Forum team, is to ensure that our legislative packages under this particular area of governance is transparent and accountable. And before I address the few comments that I'm going to make, and I will concentrate mainly on the areas where the Registrar General's function is affected, because I have the privilege as line minister to be line minister with responsibility for the Registrar General's department. I think I should take the opportunity, and the Honourable Minister of Finance has already referred to the fact that we in Trinidad and Tobago have had the opportunity over the past couple of weeks to host and to work with a 3-member team from the European Anti-Money Laundering and Countering Financing of Terrorism Global Facility, what I will refer to as the Global Facility team. The Global Facility is a body, Madam Speaker, which is responsible for supporting countries in adopting enhanced measures to increase their compliance with international AML CFT frameworks. And in a nutshell, this is precisely what our country has been undergoing over the last week or more in working with that Global Facility team, liaising with personnel. They have been here liaising with personnel from the Registrar General's Department and other key state agencies, conducting training sessions. And just yesterday, that team participated in a public beneficial ownership workshop held on the 4th floor auditorium of the government campus under the auspices of my ministry, the Registrar General's Department, and the Global Facility team itself. And from all accounts, Madam Speaker, that workshop was not only well attended, but very well received. The point there being that we are continuing to work with our international partners to make our laws stronger, more effective, and to make our financial system accountable according to international standards. The Honourable Minister of Finance has spoken at length on that, and as I have already said, I do not intend to repeat very much of what he has said. A perusal of the bill before us, Madam Speaker, reveals that clauses 11, 12, 14, 17, and 18, in particular, pertain to amendments touching and concerning the function of the Registrar General's Department, and it is those clauses in particular that I will just emphasize by way of my remarks today without repeating the very comprehensive pilot of the Honourable Minister of Finance. So we have Clause 11, which amends a section, among other things, amends Section 33 of the Act to delete the existing subsections 4 to 14 and to bring clarity and finality to the thorny issue of bearer shares, share warrants, bearer share warrants, and bearer share certificates. We know that bearer shares and bearer share certificates have already been prohibited under Act number, the Act in question, which came into force on the 15th of April 1997. And the deleted subsections are now being replaced by subsections 4 to 11 to provide for the Registrar of Companies to notify to the public by Gazette an appointed date by which a particular bearer share will be cancelled, the conditions under which the bearer share warrants and share warrants may be converted by the issuing companies, the time frame within which the holder of a cancelled share warrant or bearer share warrant may approach the High Court for an order reinstating the relevant numbered instrument as a share in his name within 6 months of the commencement of the new subsection, Section 33, subsection 7, and the obligation of the Registrar of Companies to establish a register of share warrants issued in Trinidad and Tobago prior to the commencement of the Companies Amendment Act number 6 of 2019. Madam Speaker, Clause 11C in particular deals with new obligations on companies to include information on nominee shareholders, if any, their nominators, and particulars applying to both their cohorts and the obligation to ensure that information on the register of members of a company is not to be removed from the register for 6 years after a person ceases to be a member. The obvious intention being for the transparency of the shareholding to continue to be available for appropriate scrutiny. Clause 11G, and I'm not going to go through all of them, I'm highlighting those which particularly impact on the concepts of beneficial ownership and transparency. And we have the example in Clause 11G, which amends Section 318(1) of the Companies Act to delete the existing paragraphs N and O, substituting new paragraphs N, O, and P, requiring external companies to disclose full information about their shareholders or members, and the Minister of Finance has spoken of that, inclusive of their addresses and occupations, whether they are nominee shareholders, their nominators, and so forth. These are new particulars to be furnished when an external company is seeking registration as such under the Act. Clause 11H also creates a new Section 328 to enable the registrar to monitor and regulate defaults by external companies where they fail to send to the registrar any return, notice, document, or prescribed fee. Due process is assured. The external company where the registrar requires certain acts to be done may appeal the suspension or cancellation of its registration to the court. Clause 11J amends Section 483 of the Companies Act by inserting after subsection 2 new subsections 3 and 4, respectively. 1, to enable the registrar to carry out such analysis of information within his or her possession as he or she considers appropriate for detecting inconsistencies and inaccuracies. And secondly, to empower the registrar to issue a notice to a company specifying in what respects the registrar considers any document submitted to him in relation to that company contains information which appears inconsistent with other information in the records already kept by the registrar, and requiring that company within 30 days of the date on which the notice is issued to take reasonable steps to resolve the inconsistency, inclusive of submitting amended replacement or additional documents or in any other manner determined by the registrar. And Clause 11K amends Section 489(1) to insert a new paragraph to enable and empower the registrar to strike off a company from the register if the registrar has reasonable cause to believe that any information is misleading, false, or deceptive in a material particular contained in an application for the incorporation of a company, registration of an external company, or in supporting documents. Madam Speaker, Clause 12 deals with the Registration of Business Names Act, and Clause 12A, as an example, repeals and substitutes the existing Section 3 with a new section, Section 3(1)A, requiring all firms and individuals to be registered according to the provisions of the Act in order to carry on business in Trinidad and Tobago. The provisions with respect to the amendments to Section 328 of the Companies Act in relation to external companies, that concept equally applies by Section 9B of the Registration of Business Act. Madam Speaker, the Non-Profit Organizations Act is addressed by Clause 14, and there is a new subsection, subsection 2A, which is added after subsection 2, with empowering the Attorney General, and the Honourable Minister of Finance has already addressed that, to apply to the High Court for an order of forfeiture of property of an NPO, the registration of which has been cancelled by the Registrar General. So we see a constant approach to strengthening the powers of the Registrar, including, in an appropriate case, allowing the Attorney General to apply to the High Court for enforcement powers. And that brings us, Madam Speaker, to Clause 17 of the bill before us, which addresses important concepts of the term beneficial ownership. And it is one of the most significant amendments that has been introduced by the suite of amendments that is before this House today, and indeed has prompted further contributions from the Global Forum team with respect to the further amendments which the Honourable Minister of Finance has already spoken to, and I will address that in due course. Clause 17A amends Section 10A(2) of the Trustee Ordinance to insert a new definition of beneficial owner to mean, among other things, the settlers, trustees, protectors, beneficiaries, or class of beneficiaries exercising ultimate effective control over an express trust directly or indirectly through a chain of control or ownership, and whether a domestic or foreign trust. Clause 17A(3) inserts a new section, Section 10AA, which would make Part 2 of the ordinance applicable to trusts and other legal arrangements governed by the laws of Trinidad and Tobago or administered by a trustee or administrator resident in the country. Clause 17A Roman 3 amends Section 10B of the ordinance to place an obligation on a trustee to identify the beneficial owners of an express trust and to verify such identity by conducting adequate due diligence procedures as required by the laws of Trinidad and Tobago, as well as to verify that the information remains current and correct, and to keep a record of it. Clause 17A Roman 4 makes several amendments to Section 10C of the ordinance, including a requirement under a new Section 10C1 that a settler and other persons identified as a beneficial owner submit to the trustee a statement in a prescribed form delineating required information together with supporting documentation within 30 days of the commencement of the section or other date prescribed by the minister. A new Section 10C(5) will be inserted to empower the trustee to apply to the court for an order of suspension of the rights of a beneficial owner who does not comply with the provisions of Section 10C(1). And Clause 17A Roman 5 clarifies the obligations and duties of a trustee or administrator of any other form of legal arrangement as set forth in Section 10D of the ordinance by deleting subsection 2 and repealing and replacing subsection 3. Madam Speaker, the new Clause 17A Roman 6 repeals the existing Section 10E of the ordinance, replacing it with a new Section 10E requiring the Registrar General to keep a register containing information with respect to 1, all the parties to express trusts or legal arrangements which are subject to the laws of Trinidad and Tobago, and 2, the beneficial owners of all such trusts. And that register, whilst not being accessible to the general public, is expressly available only to the director of the FIU, the chairman of the Board of Inland Revenue, a police officer or the rank of superintendent or above, attached to the division or unit of the police service responsible for financial investigation or fraud, or by virtue of a court order. So it is strengthening the transparency and the reach of the appropriate agencies and indeed the police service who have oversight to ensure honest dealings in this particular area. And I would mention, Madam Speaker, that only last month, as we go into our mutual fifth round, only last month we had, the Attorney General's office had a fascinating retreat in St. Joseph with all of these agencies that are responsible for oversight of financial management, as we got together to understand, as we continue to do, as a work in progress. And this addresses the criticism of the member for Barataria San Juan, who suggests that the legislation is being amended in a less than comprehensive way. The point is that we continue to work progressively amongst ourselves. We did that in July last year. We came together. It was the Attorney General, the securities agencies, the FIU, the Central Bank, the Financial Investigative Unit of the Police Service, a number of different agencies getting together to share information and to work on that accountable transparency. And as I opened and said earlier, only this week, as we speak, the press release went out today to announce the conclusion of that very informative session. We were working with the Global Forum team, and out of that work, we are before this House today, and the Minister of Finance has spoken to that, with some further amendments that we are asking this House to approve. So it is a work in progress which we continue to adhere to, not in a less than coherent way, but precisely in a coherent and progressive way going forward. Clause 17F, Madam Speaker, amends Section 9 of Act Number 1 of 2024, which amended the Partnership Act. Repeal sections are replaced by Section 20A to 20E. Section 20A, again, would define, this is in relation to partnerships, would define beneficial owner, minister, and registrar. Section 20B would require firms to identify, obtain, and verify and keep beneficial ownership information and maintain and keep updated a register of beneficial ownership information. And Section 20B requires firms to maintain that beneficial ownership information, as in the case of companies to which I've already referred, on the register for a period of 6 years after a person ceases to be a beneficial owner or after the dissolution of the firm, so that the ability to continue to examine the records and transparently to have oversight of the affairs of the partnerships under the Partnership Act is being addressed. Section 20C, 3 and 4 imposes obligations upon partners and beneficial owners or firms registered pursuant to the registration of business names to submit statements in prescribed form to the firm together with supporting documentation. And a like obligation is imposed whenever a change occurs in the beneficial ownership of any firm or the particulars of a beneficial owner, or a notice under Section 20C, subsection 7, is issued to partners and beneficial owners. Madam Speaker, I could continue at length, but I am just going to highlight a couple more parts of this very important omnibus bill that is before this House. So we see, in relation to non-profit organizations, Clause 17H amends Section 11 of Act Number 1 of 2024, the Trustee Act, which in turn amended the Non-Profit Organizations Act, and has introduced by Section 3 of the Non-Profit Organizations Act a newly introduced definition for the first time of beneficial owner, providing that a beneficial owner will be the controller of an NPO. New Section 21A1 will require an MPO to identify and obtain information as to all controllers of non-profit organizations verify their identities by adequate due diligence procedures as required by the laws of Trinidad and Tobago, and verify the currency and correctness of all of that information. And there are penalties for non-compliance. So Section 21A2 will render a non-profit organization that is non-compliant with Section 21A subsection 10 liable on summary conviction to a fine of $50,000. Madam Speaker, Clause 18 deals with amendments to the miscellaneous provisions, Registrar General Companies, Registration of Business Names and Non-Profit Organizations Act, Act number 4 of 2024. So we see that Section 9B is a crucial tool that is being given to the Registrar General's toolkit insofar as the Registrar General is empowered to monitor and maintain supervisory responsibilities in relation to these organizations. I could continue, Madam Speaker, but I will turn lastly, before I take my seat, just to emphasize the amendments that have been brought in to our attention in the work that we have done this week with the Global Forum team, and I will summarize those amendments which the Minister of Finance is introducing. Clause 11 of the bill, which amends the Companies Act. Primarily, those amendments are to correct minor typographical errors and to ensure that all particulars of persons holding membership interests in the company are maintained in the Register of Members. Clause 17, amending Act number 1 of 2024 in relation to the Trustees' Ordinance. Those amendments are intended to improve the beneficial ownership disclosure framework for trusts and other forms of legal arrangements by, for example, inserting the definition of Registrar General with whom the information is to be lodged relative to beneficial ownership disclosure, introducing a registration framework for trusts with the Registrar General, inclusive of the issuance of a certificate of registration by the Registrar General, penalties for failure, provisions for the issuance of certificates of good standing. All of these are aimed at ensuring that all trusts within Trinidad and Tobago may be identified and to allow the Registrar General effectively to monitor and ensure compliance by these legal arrangements. Additionally, revising the suspension and/or cancellation regime under the Trustees' Ordinance for failure to report beneficial ownership information to the registrar in light of the new requirement for registration under the Trustee Ordinance. And further, together with the above, insertion of further provisions to allow for due process, fairness in the process by including the right of appeal of decisions and the ability to have the trust registration restored. Further expanding the application of the Trustees' Ordinance relative to beneficial ownership information and disclosure to those trusts and other legal arrangements with assets touching and concerning Trinidad and Tobago, consistent with international best practice for the anti-money laundering and countering the financing of terrorism. Additionally, Madam Speaker, removing the requirement for filing an annual return, as trusts and other forms of legal arrangements are not likely to report changes with frequency, thus alleviating such entities from unduly onerous filing requirements. And importantly, the correction of minor typographical and numbering errors and omissions. And then in relation to Clause 17 affecting the Proceeds of Crime Act, the amendments seek to correct the definition of beneficial owner to ensure clarity and the applicability and consistency of this act within the broader legislative framework for beneficial ownership disclosure. With respect to the Partnership Act, Madam Speaker, the amendment shall again correct minor typographical errors and omissions, align the definition of beneficial owner by inserting words which will capture partners who are natural persons, and the insertion of an obligation for the Registrar General to maintain and update the register of beneficial owners of all firms. And finally, moving to Clause 18 of the bill amending Act number 4 of 2024, the amendments seek in relation to the Companies Act to correct minor errors and, importantly, to provide for the revision of the prescribed legislative framework for companies and external companies. The current process, Madam Speaker, whereby a company issues a notice and thereafter the legal and beneficial owners are required to reply by statements to the company, is predicated on direct legal owners, that is, shareholders and members holding more than 10% of the shares or membership interest, to identify the beneficial owners of those shares or membership interests. This process, now that there has been a transition away from the particular share being held to the ownership of a company as a whole, will inadvertently cause our companies to report beneficial ownership information incorrectly, and we are seeking to correct that. And therefore, it is imperative that just as the threshold has been introduced, that we usher in a new revised mechanism by which companies are enabled to ascertain and identify their beneficial owners, even where those persons, as the Minister of Finance spoke to earlier, may be seeking to disguise their ownership through split ownership or various holding companies. And as such, we propose to remove the requirement for the issuance of the notice and statements and to allow companies the freedom and autonomy in finding and identifying their beneficial ownership. This process will certainly simplify the process with innumerable practical benefits, of which I will name only a few. Reducing administrative burden for businesses, reducing the opportunity for error, aligning the procedure with international best practice, and consequently increasing compliance by the companies, as the process will be far easier to be carried out. Madam Speaker, this is a suite of amendments which is consistent, as I said when I opened, with the intent and mandate of this government to transparency and to increase and improve our efficient corporate and international financial obligations, and I thank you.
Member for Superior.
Thank you very much, Madam Speaker. As we begin this final session of the parliamentary term of that government, Madam Speaker, I take this opportunity to wish us all in this honourable chamber a very productive legislative session. We don't know how long it will last, but whatever time it is, this is the final session of the parliamentary term of the present government. I pray that we work in the interests of the people who put us here to ensure that in all we do, we aspire to make their lives better within the spirit and intent of our nation's democratic constitution. And with this aspiration in mind, I rise now today a brief contribution on this very important bill. Madam Speaker, you'll permit me 1 second, please, just to veer off, but I will definitely concentrate on the bill before us. This is really the swan song session
Madam
of
Speaker,
the government.
Standing Order 53, please.
Minister of Finance, I'm on my legs. I know you all might be discussing something, but it is disturbing the contribution of the member for Superior. Member, please.
I thank you very much, Madam Speaker. I know some people are a little jumpy because they will no longer be sitting on that side of the House. The people shall remove them from that side of the House. So thank you for your protection, Madam. So this is the Minister of Diego Martin Northeast. The next time we see you will be at the end of the bench.
Minister of Finance and the Leader of the House, maybe the conversation could take place outside. It is a bit loud. Okay, so for a conversation, there needs to be two parties. All right, so I'd ask if the conversation is going to continue, if it can take place outside. Member for Superior.
I thank you, Madam. You know, Madam Speaker, the Honourable Prime Minister has been out of TNT for about 372 days. 370 days. 72 days, okay? And I'm not counting this last trip. I don't know how many days. I don't know when you return. That's more than a year. Yeah. 372 days, not counting this final trip. And the Honourable Minister of Finance has acted for the majority of those 372 days. So I guess he's a bit jumpy because he acted so much. I once recommended him for an Oscar or for a Golden Globe Award. So I guess he's jumpy, he's gone. I guess they're having a conversation, you advise, outside the chamber. And in the past few weeks, I noticed the Minister of Finance has been downgraded. Now, I know I was promised at some point in time, thanks to the great people of Trinidad and Tobago, and with their help, I shall become Prime Minister again, Madam Speaker. But I have never seen that when a Prime Minister is out of the country, his nameplate is moved down the bench. Yes. Look at where Diego Martin West is. So maybe the rumors are true that the Minister of Port of Spain North, St. Anne's West, is to become the next candidate. We don't know. But I've never seen that you move the nameplate 1, 2, 3, 4, 5th along the bench. Even the Minister of Finance, who is now not in the good house, is in front of Diego Martin West. It's very interesting. It's very interesting. And, you know, there's a young actor now on the seat, taking over for the Prime Minister whenever he's out of the country. Oh, it's the Prime Minister's prerogative to put whomever he wishes to put. I have no problem. But why you put him on down there, please? No. The seating in the House is the prerogative of the leader.
Excuse me,
with the chief whip.
I'm on my legs. While I understand a little banter, the conversation is not a two-way conversation. So, Member Faruqa Maloney, I'm sure you'll get your opportunity. Member for Superior, remember the conversation is this way. Member for Superior.
Oh. Thank you, Madam. Thank you so much. So I congratulate the honourable member for Port of Spain North, St. Anne's West on his elevation, his active appointments and so on. Minister of Finance, I really hope you come to read the budget because I love to see your smiling, happy face. I hope Port of Spain North doesn't take over that role from you as well. So, Madam, let's move on. I've been accustomed to see the nice smiling face of the member for Diego Martin Northeast, who has now been elevated to Attorney General and appears in that seat. So we look forward to your budget contribution. We're keeping our fingers crossed, hoping that you will continue to read the budget. Now let's get to this bill before us. This bill is a very important bill, as other members have said before. I want to congratulate the honourable member for Barataria Sanwa on his contribution to the bill in this debate. And we keep hearing the words Global Forum. What is a Global Forum, Madam? Global Forum is an international body which seeks to implement global transparency and exchange of information standards in respect of tax matters. And so what happens here today? MP for Barataria called it an omnibus bill. Why? Because this one bill attempts to amend 16 statutes on our books, 16 laws on our books in one rush to go. Why? We'll find out why. MP Barataria Sanwa talked about blacklisting. Since 2017, Trinidad and Tobago has been blacklisted by the Global Forum. What does that mean? The Honourable Minister, who was then the Attorney General, the member of San Fernando West, had told us that, you know, when we are blacklisted, we lose correspondent banking. That happened when? 2017? 2017. So since 2017, we are on the blacklist by the EU, by the Global Forum. And the member for San Fernando West told us we will lose correspondent banking. What is correspondent banking? That to say, our banks, banks in the EU and elsewhere, that we can have a cooperative relationship, or banking will be accepted by them and we'll accept their banking and so on. So I don't know if that has happened. The member for San Fernando West, I'm sure, will be very happy to advise. Have we lost correspondent banking since 2017? When we went, well, please, I'll be happy to hear it. Because as far as I remember, my banking is still working. The credit card works some days and some days it doesn't work. And that's a banking matter. Correspondent banking, please tell us. But you know what is more important, Madam? Is it a consequence of us being blacklisted by the Global Forum, by the EU, that the UK on their website has put out this? The UK ETA for Trinidad and Tobago citizens, a guide. Citizens, this is 10 September, today is what, the 13th, 10 September. Citizens of Trinidad and Tobago will need to apply for an ETA to visit the UK starting on January 8, 2025. What does it mean? Before, you just pick up your passport, buy your ticket, go to the airport, and you could travel to the United Kingdom. That's how I knew it all these years. Now we have to get an ETA. The system will allow eligible passport holders of TNT to apply from November 27, 2024, which is in advance of the enforcement date. There's a guide on their website how the system will work. So what this in effect is doing is restricting our travel to the United Kingdom, which we didn't have before. So while they're saying you're not a visa, you don't have to get a visa, but you have to get this electronic permission to travel to the United Kingdom. Is this also a part of this EU blacklisting, Global Forum blacklisting? I'm sure the members will be happy to tell us. So here we are now with this omnibus bill, 16 key statutes to be amended to bring them into compliance with Global Forum. But I'm very concerned about this, because we always had, I remember when I was Prime Minister, we were in government, that the United Kingdom tried to enforce us to get visas and to get these kinds of restrictions on travel. And we worked with the United Kingdom government, and it did not happen. Now in 2024, Madam Speaker, any TT citizen now has to go through this screening process, apply, they could, and listen, they can reject you or approve you. So while it's not being called a visa, it is in effect a restriction on your travel rights to the United Kingdom. Let's see which other EU countries will do this. So blacklisting has consequences. In the same way that elections have consequences, blacklisting has consequences. 16 pieces of legislation to comply with the Global Forum framework. 1, amendments to the Prevention of Corruption Act, Chapter 1111. 2, amendments to the Proceeds of Crime Act, Chapter 1127. 3, amendments to the Anti-Terrorism Act, Chapter 1207. The National Insurance Act, Chapter 3201. The Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201. 6, the Income Tax Act, Chapter 7501. 7, Corporation Tax Act, Chapter 7502. 8, Petroleum Taxes Act, Chapter 7504. The Companies Act, Chapter 8101. 10, the Registration of Business Names Act, Chapter 8285. 11, the Tax Information Exchange Agreements, United States of America Act, number 4 of 2017. 12, the Non-Profit Organization Act, number 7 of 2019. 13, the Tax Information Exchange Agreements Act, Act number 5 of 2020. 14, the Mutual Administrative Assistance in Tax Matters Act, number 7 of 2020. 15, the Miscellaneous Provisions, Trustees, Exchequer and Audit Act, the Minister of Finance and Corporation Act, Proceeds of Crime, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations and Mutual Administrative Assistance in Tax Matters, Act number 1 of 2024, just recently, this year, Act 1. All these various statutes were amended, and we're back again, trying to amend once more. And finally, number 16, the miscellaneous provisions, Registrar General Companies, Registration of Business Names, and Non-Profit Organization Act, number 4 of 2024. So my colleague, Baratara Sanwan, member, talked about an omnibus bill, and it comprises about 119 pages, madam, 100, with very long, detailed clauses. So say how many clauses is not sufficient. The clauses are very lengthy and very detailed. So this is a very significant piece of legislation before the House today. And, you know, madam, I really do not understand how this government operates. It's a bill dealing with major amendments. I've outlined 16 pieces. The Prevention of Corruption Act being amended, Clause 3 of this bill, brings in a new subsection to Section 9 regarding the powers of police to inspect financial records and other documents. The new subsection stipulates on an application from the DPP for an order to authorize police entry, search, inspection of premises for the purpose of obtaining financial information and other relevant documents. The judge shall consider whether the provision of tax information received by the BIR on the tax information exchange agreement is permitted by that agreement. So I heard one of the members on the other side talk about due process. You go before a court and the judge will, in his discretion or her discretion, will decide. So that is what we are dealing with. Access to your financial documents, not just through the courthouse, but in your home. They can go to get a search and enter your house to find your financial documents. So this is serious legislation. And whilst it requires on the face of it a simple majority, the question must arise as to whether that kind of access to personal information, private information, your home is your castle, whether that should be readily accessible and whether the due process spoken about is sufficient to override the constitutional provisions. That is something I would be very happy if the Minister of Finance in wind-up can please address. So when the government breaks with tradition to bring such a major piece of legislation of this first day of this session, we have to wonder why. We got notice of this debate, Madam Speaker, I'm sure you are aware, on Wednesday. On Wednesday, today is Friday. And yesterday, by letter dated Thursday, September 12th, we were told we'd be debating this bill through all its stages. Massive piece of legislation, impacting on your personal information, your financial information and so on. Wednesday, 119 pages of this bill. And then yesterday, Thursday, we advised by letter dated Thursday yesterday, we were told we'll go through every stage of this bill. Now, that is bad enough. But then I'm listening to the Minister of Finance in his piloting, telling us that he has what? Voluminous amendments. I haven't had sight of them. I can't even speak to them. When will we read them? What is voluminous? When will we see them? We have a duty to pass law in keeping with the best interests of the people of Trinidad and Tobago. And you blindside us. You blindside us. Wednesday, you say we're doing this. Yesterday, we're going through all stages of this 119 pages. Until you're coming out. I don't know if it's on the table. The amendments, have they been tabled, Madam? I don't know. We have not received it. How can we speak to those amendments at this 11th hour? And so that is, again, I think, disrespect and contempt for the people we represent. But then, we should not be surprised, somebody told me, PNM means people never matter. This is the most anti-people government I've ever seen. And I've been here a long time. So you come to debate this major piece of legislation, and then now, in this 10th year of your government, you come in your swan song appearing, you're rushing this major piece of legislation. I think, well, you'll hear it again, sir. You will hear it again. I like to see your smile. You're always grinning. You will hear it again. That is shambolic, chaotic conduct of the business of this House, Madam, and I condemn the government for this kind of approach to legislation. I don't know if you thought this 119-page bill, amending 16 statutes, 16 laws, you'll catch us by surprise. Oh, no. As our speaker before me and those coming after us, we are ready to battle you in the Parliament and outside the Parliament. And mark my word, in the same way, whenever you pull that out your back pocket, I don't know if Port of Spain, North, St. Anne's, West has that. Whenever you pull it, it licks like fire and it licks like fees in that election. You will not take us by surprise, not this time. So you see, Madam Speaker, this approach, Port of Spain, North, I will sit if you want to shout across the floor. What is AA? I am on my legs. Madam, oh gosh, man. You're acting Prime Minister, you're feeling big in the dance. Behave big in the dance,
So,
man.
members, let's continue with the debate. It's the first day of the session. Let's give each other the respect demanded, and let's get on with it. Member for Superior.
Behave like a Prime Minister, no boy.
That and you will never see. Thank you, Madam. So this kind of approach to conducting the business of the chamber, Madam, reflection on their failed legislative agenda 10 years down into the road. For going into 10 years, you have failed. 2 attorneys general consistently failed to deliver a comprehensive legislative agenda, even though you boasted we have a good agenda, don't worry. Madam, you may recall that towards the end of the last session, June to July, the government suddenly became very busy in this parliament. Very busy. They rushed through several pieces of law, legislation, and they come again to rush this one today. But let's look at it. It's a piecemeal approach. I remember the Attorney General has not delivered on a sustainable program of legislation to enhance the development of Trinidad and Tobago. Not one. In our budget debate last year in the Senate, 15th October 2022, the then AG, this AG, committed he would bring a suite of legislation targeting a cross-section of our national, societal, and civic issues. And he stated in the answer this there, quote your own words, Madam President, through my office and the Legislative Review Committee, this government intends to introduce a suite of legislation targeting a cross-section of national, societal, and civic issues, all for the betterment of the people of Trinidad and Tobago. What happened? Nothing happened. He said the government places top priority on the need to drive economic activity, and, as recognized and saluted by the Honourable Minister of Finance, to improve the ease of doing business for companies and so on. All fluff, all fluff. None of that has happened. This was done since last year, nothing. For the past 2 years, there's lie, cry, and mama guy, and deny at the end of it. Lie, cry, mama guy, and deny. For the past 2 years, we heard this AG talk about crafting effective legislative agenda. And he said this, madam, we acknowledge this is a work. There's lots of work to be done, said on 25th April 2023. So said, but not done. And for the years before that, we had the immense misfortune of hearing the predecessor of this AG repeating the same bluff about a legislative agenda. We will have a proper legislative agenda. Well, you come and tell us, sir. You'll have your turn, sir. You will have your turn, San Fernando West, and I look forward to hearing you. You're always very, very eloquent, full of noise, with no substance. So whilst it promises robust agenda, it hasn't happened. That worry you? When you move Mr. Rowley down to seat number 5, talk about that. I want to know why you all did that. Tell me what. So when we look at sittings, I'm saying you will see there has not been a comprehensive agenda for legislation. I want to make it very clear, madam. Without doubt, the government will come with this tired, false mantra in this final session that they cannot possibly get a proper agenda. Because why? They will say, because of the opposition. Blame Kamala and blame the opposition. They can't do anything. Well, the answer to that is simple. Just get out of office and put this side in the government bench and we will get it done. We will get it done. So you'll come to say, well, you couldn't pass it and you couldn't get it done. I want you to see, I want you to know from the outset, I want to make this very clear. The Hansard record will show that we in this opposition have supported every single piece of legislation with respect to getting us off the blacklist, with respect to rule of law. MP for Barata talked about factor on steroids. We supported factor. Even you go and lie, cry, and mama guy and fool the country. We supported everything relating to get us off the blacklist. We have supported every single piece of legislation. And yet still, today, 2024, September 13th, you've been there for over 9 years, going into 10. You have put us on the blacklist. You promised to take us off the blacklist, and up to today, we are on that blacklist. Let's look at that. This is about the 8th time, madam, since the government came into office in 2015. This is about the 8th time we are attempting to deal with legislation to get us off that global forum blacklist, the EU blacklist, European Union blacklist. The government has not yet been able to do this. And Madam, according to the European Council, I think my colleague may have quoted this, the European Union Council, I quote, this is what they have to say about Great Trinidad and Tobago. On 20th February 2024, I'm quoting from that Council's meeting. That's this year, February 2024. The Council adopted the EU list of non-cooperative jurisdictions for tax purposes. It is composed of 12 countries. The list becomes official upon publication in the journal. And these are the jurisdictions that are non-compliant for tax purposes. I continue to quote from the Council's minutes. The EU list of non-cooperative jurisdictions for tax purposes is part of the EU's work to fight tax evasion and avoidance. It is composed of countries which have failed to fulfill their commitments to comply with tax good governance criteria within a time frame, and countries which have refused to do so. These countries are, my colleague I think had named them, I want to name them for a reason. American Samoa, Anguilla, Antigua and Barbuda, Fiji, Guam, Palau, Panama, Russia. We are in the same category with Russia, madam. We pride ourselves on being a great democracy, and we're in a category of nations for non-compliance, and we're in the same category with whom? Russia. Shameful, madam. Samoa, Trinidad and Tobago, U.S. Virgin Islands, and Vanuatu. These are the non-compliant nations according to the European Union Council. The countries listed are within scope of the EU screening process. That's what the EU is saying about us. I want to repeat, it is disgraceful, it's a dangerous stain on our country's international and regional reputation. And CARICOM, like Barbados, Jamaica, they are way ahead of us. What has gone wrong with us? What is wrong that Trinidad and Tobago finds itself in this dangerous and disgraceful position? You know what? They may not have this, they may not have that, but you know what they don't have? They do not have the PNM. They do not have the PNM. Barbados, Jamaica, they're off the list, they complied. And as my colleague from Barata told us, they've been warning us since 2017. And this government has failed and or neglected and omitted to take us off that list. And you know, Minister of Finance said something very interesting in his piloted. I heard him saying, well, yes, we pass these laws, but we have to get the regulatory framework in place. Because this government promises, PNM promises never materialize. And then it doesn't happen. So passing it here today in the Parliament, and we will support this, I make it clear. We are supporting this. We want Trinidad off the blacklist. TNT off the blacklist. So after it's passed here and then in the other place, you have things to do. How many laws are on our statute books that are not implemented, passed, and still not proclaimed? This law tells us it will take effect on a date to be proclaimed. Give us an idea when you plan to proclaim it, please. So that's the first step. And then all the ancillary matters that may arise from passing major major legislative changes like this, how soon you have to get this up and running? Tell us, please. Because I want us off that blacklist. I think everybody in the country wants us off that blacklist. Since 2017, you have TNT on a blacklist. I think that is very dangerous, very shameful, and very disgraceful. And then you want people to come and give you another 5 years. I say, call the election, please. Go out of office and we will get it done. This UNC will get it done. It remains disgraceful. The Hansard record will show, Madam Speaker, that the UNC has supported every piece of legislation which relates to getting us off the EU blacklist, the Global Forum blacklist. So many of our members on this side have asked in the past, and I repeat today, is it that the amendments we are making today is being done to address our EU blacklisting standard and our compliance with the Global Forum? If the answer is yes, then I ask, exactly how many times does this government intend to bring us here to pass pieces of legislation to finally get it right, to get us off the list? My colleague from Barata said it many times. I think it's the 8th piece of legislation. What happens now? Next week, next month? Just in February, we passed an omnibus piece of legislation, some of which we are re-amending today. We're amending again, Madam.
Member for Superior, you have 2 more minutes of ordinary time left. You're entitled to an additional 15 minutes extended time if you wish to avail yourself of it.
Very grateful, Madam. Please, I will take the additional 15 minutes of speaking time. I thank you very much. So do you have to come back again after today? Well, you have already come back. Since you laid this bill, and that's a strange thing, you know. I didn't know you could lay things on the order paper whilst the Parliament is prorogued. It was a dead Parliament. It's dead. It was sleeping. It was prorogued. And it's only this morning proclamation read. So can you create an order paper whilst the Parliament is prorogued? Well, tell me, Member for Salmon and West, you know everything. Tell us. You will have your turn. Tell us. Tell us, please. I'm asking. Just asking for a friend, okay? So you will please tell us, okay. So I'm asking how many times? Are we going to come back? You came in February with an omnibus. You're back again today with an omnibus. And before that omnibus is even passed, another voluminous piece is coming for amendments. Now, this is whatever is your answer, based on your track record, I think at the end of this, we will still be in the same blacklist as we go forward. Madam Speaker, when we look at the legislative history, from 2015 to now, with respect to these legislative changes, we had the Tax Information Exchange Agreements United States Bill 2016. So we're dealing with tax compliance or issues legislatively dealing with tax. That was an act to repeal the Tax Information Exchange Agreements Act, replace it with the Tax Information Exchange Agreements US Act, which would have made provision for implementation of agreements between TNT and the USA, provide for the exchange of information for the purposes of tax, the validation of the sharing of personal information held by the BIR or financial institutions, and for related purposes. That bill was preserved from the first session of this Parliament, the 11th Parliament. We are now in what, the 5th session? 5th session. It was preserved from the first session of Parliament, and there it went. 9 September 2016. These were things to help us get off the blacklist, huh? 9 September, in this House, the bill was read. On July 6, 2017, it was proclaimed. A second piece of related legislation, the Mutual Admin Assistance in Tax Matters Bill 2017. That act was to implement the Convention on Mutual Administrative Assistance in Tax Matters, to make provision for implementing agreements between TNT and other states, again to provide for tax exchange information and matters thereto related. Let's see the bill progress. Bill 21 April 2017, House of Representatives, first reading. 21st September 2017, the bill lapsed. We didn't push it forward. Blacklist now, 2017. The tax bill 2018 then, a third one, 2018. So we tried in 2017, the bill was allowed to lapse. We were put on the blacklist. Came back on in 2018 to do similar things for tax exchanges and so on. 28 May 2018, read in the House. March 26, 2020. So this started, as I say, in 2017 and did not get the President's assent until 26 March 2020. All this time we're on blacklist, still on that blacklist. A fourth related piece, the Mutual Administrative Assistance in Tax Matters Bill 2018. This was to deal with the Multilateral Convention on Mutual Admin Assistance in Tax Matters. This was a bill in 2018. What happened? Didn't do it. It was brought forward. You know, we brought forward a lot of things last week, carried over. It was brought forward from the third session and then the fourth session. Yes, Monday. Thank you, Aruka. Very kind of you. On Monday, we brought forward several pieces of legislation. I think this was one of them too, this bill. It was brought forward from the third session, then the fourth session. 25th May 2018, in the House, first reading of that bill, 2018 bill, in May 2018. 26 March 2020, assent by the President. I'm told it's still awaiting proclamation. Can you please clarify, Member of San Fernando West, you seem to know all these matters well. Is that still awaiting proclamation? Is it still awaiting proclamation? Passed 25th May 2018 in this House. Is it still awaiting? So are we serious? Do we want to get off the blacklist? Do we pass laws and keep them in the books and don't proclaim them? Tell me I'm wrong. I'll be very happy to hear I'm wrong. I'll be very happy because we're one step closer to getting off the blacklist. Another one, item 5. You see how many pieces, madam? All of this related to getting us off the blacklist. And in 2024, since 2017, in the final year, in the last days, rushing this through, and how many more times will we come back? Look, 5, miscellaneous provisions, Registrar General, Companies, Registration of Business Names and Non-Profit Organization Bill 2023. And today, whilst we are here sitting in this House, we are being told you have more amendments to deal with the Registrar General. You got it? This is it. Voluminous amendments. I'm sorry, this is the amendment. Guess we'll speak in the committee stage. Back to the BIR. We'll deal with it at committee. I just got a copy. So more, today, more amendments. 6. 5 was Registrar General. That's companies, land registry, and so on. And then we come to the progress of that bill. 24 November 23, first reading in the Senate. 1 May 2024, assented and proclaimed. This one is proclaimed. Then we have the Base Erosion and Profit Shifting Inclusive Framework, Country by Country Reporting Bill 2023. What happened with that one? 24 November 23, first reading in the Senate. 19 March 24, assent by the President. But guess what? This is another one from our research, we're being told, has not been proclaimed. Has not been proclaimed. What's the point? You come to the Parliament, we stand up here for hours, we speak, we devil in the law, as you say. You give your views, we give ours, and at the end we hope we get a good mix. And then you don't proclaim it. You pass it and you put it down there. How many pieces of legislation have not been proclaimed? How many? But this is important for this debate because these are part of the compliance framework to get us off the blacklist. So still awaiting proclamation. 7. Miscellaneous provisions, trustees, exchequer, and so on. We are back here again today, amending again the same exchequer, trustees, Minister of Finance Act, proceeds of crime, income tax, companies, etc., etc. That bill came here, 24 November 23, Senate first reading. 22nd February 2024, President's assent. So we're back again to amend that again. Will we ever get it right after 10 years, Madam, to get off the blacklist? Act number 8. Miscellaneous Provisions Global Forum Bill. We're here back again today dealing with our Global Forum. 2024. Again, that was an act to amend Prevention of Corruption Act, Proceeds of Crime, Anti-Terrorism. I'm going to go through the list, ma'am. I already talked about the 16 pieces of legislation we're amending. We did that already here. But we are back again here. We're doing what? Amending and amending and amending. When will we get it right? This bill was brought forward from that last session to this 5th session, and that's where we are. 3rd July, first reading of the bill in the House, and then brought forward last Monday, and back in the House today. Same old pieces of legislation. Then there is the Tax Information Exchange Joint Select Committee report. A report of the JSC on the income tax amendments, tax information exchange agreements, 2019, JSC, in the 11th Parliament. It was presented in the House on November 22, 2019, Senate November 26, 2019. Now, where are we now? 2024. You all are not serious. I thought you could feel happy, smiling, and you drop in an airport somewhere and only people blacklist. EU blacklist. I heard the minister talk about some place in Italy, if I'm not mistaken, I think. Some place in Italy. We are on their blacklist. And for 2017, 18, 19, 20, 21, 22, 23, 2024, we have been on that blacklist. And it's not like you were not aware, you were warned. MP for Barrett mentioned where we were warned. And you have come several times, but you just can't get it right. You just cannot get it right. I don't know if it's incompetence, laziness, or both of those things. You just cannot get it right. 6 minutes, thank you. There was another JSC report to consider and report on the Mutual Administrative Assistance in Tax Matters Bill 2018. 2018, this is 2024. Then, Income Tax Amendment Bill 2019 in the 4th session. We are now in the 5th session. It was presented in the House September 20, 2019, in the Senate September 25th, 2019. What has happened? We are in 2024. There was a second interim report of the JSC on mutual admin assistance in tax matters. So a lot of these same things we're dealing with here today. 4, there was an interim report of the JSC to consider on mutual admin assistance in tax matters, same matter. That bill was a 2018 bill. Presented in the House in 2019, Senate April 2nd, 2019. Another report, madam. So we've been doing this for 9 years, repeat into 10 years now. Over and over we've been doing this. That one on special report to consider report on the Income Tax Amendment Bill 2018, presented in this House, November 30, 2018. Another report of the JSC, 2018, presented here September 17, 2018. We are in 2024. I know it goes ad nauseam, but that's how we've been doing this over and over and getting it wrong, every time getting it wrong. That today we are here when we could be dealing with real issues of people, the cost of living, the cost of fuel, the cost of housing, crime, the number one issue. And madam, we have been picking up, we are on the ground, don't just crime, you know, because something else kills you. Healthcare, our healthcare sector. The ratings are the lowest, but who could afford to fly out and go to California? The rest of us are to go line up outside a hospital or a center, health center. We had hours, late opening hours, so when you finish work, you could go, you shut that down, shut it down. No, people never matter. PNM, people never matter. Pressure, no money. PNM, pressure, no money. 7, another interim report of JSC on Income Tax Amendment Bill, presented here June 29, 2018, in the Senate July 2nd, 2018. We are living in the rearview mirror. We're living in the past. You know, when I looked at those matters laid on Monday, about 60 papers laid, only 2 were relevant for us today. That of the report of the procurement, OPR, and the one from the special report of the auditor. All the others 2020, 21, 22, we're living backwards. We could never go forward under this government. We cannot go, you're living in the rearview mirror. It's time to change them. I agree with you, MP. 8, report of the JSC again. 3 minutes. A 2016 bill, we had a JSC report, February 23rd, 2017 here. What happened with that? So you had this under the radar. You had it in your sights. You had it in your sights since 2016, 17, 18, 19, 20, 21, 22, 23, 24. And when we're done here today, we still have to go in committee now and make these amendments. And then tomorrow, we see what tomorrow brings. Then you had a ministerial response of the Tax Appeal Board to that first report. And it continues, madam. There's several others like this. I just have 2 minutes there. So we will continue to call the government to book. And I had a full statement in 2018 on these tax matters, because we were very concerned. I remember former Minister Hawaii, then Minister of Finance, had stated and committed that by 2017 we will come out of the grey list. You know what happened? This government came in, and from grey list we went to blacklist. So I thank you very much for your time, madam. And as I close, I say, this is not good enough, and we have to get these people out of office at the earliest opportunity. I thank you very much.
Member for San Fernando West.
Thank you, Madam Speaker. Madam Speaker, I join this debate with the welcomed news that the opposition intends to support this debate, thereby truncating some of what I wish to put on the record, but nonetheless must put on the record certain matters that are very, very, very wrong, A, in the submissions of Barataria San Juan, and B, in the submissions coming from the member for Siparia. Madam Speaker, the honourable member for Siparia joined this debate in a rather curious way, talking about everything from seating positions come down. But one has to remember that perhaps the honourable member needs to be reminded of where we have come from. The Global Forum is a combination of 160 countries that have determined that they will come together to deal with issues of taxation, tax avoidance, and to ensure that the base of taxation is as wide as it can be. The reason for the base of taxation being as wide as it can be is so that countries can get their fair share and be allowed to use monies for the benefit of the people that they represent. Trinidad and Tobago is in no different position. The honourable member complains that this government has come with omnibus legislation and that we should have come with one piece of law, being the worst approach that one could take. The honourable member says that it should be done in individual pieces. Madam Speaker, the record of Parliament will demonstrate that the government has consistently engaged the issue of the Global Forum, FATCA as it relates to the financial obligations between the United States and other places, and very importantly, the Financial Action Task Force. We are currently blacklisted by the Global Forum, and that blacklisting originated in 2011 when the government of Trinidad and Tobago, under the member for Siparia, promised effectively in its term that by September 2015, we would have completed all of the requirements necessary for Trinidad and Tobago to be compliant with the Global Forum. That was a definite written statement by the member for the government, representing the government at those meetings. That is the Minister of Finance then, Mr. Larry Hawaii. It was in Germany in 2014. The Global Forum looks at a number of metrics to say whether you are in compliance or not. There's a Pair 1 resolution, there's a Pair 2 resolution, where the countries come and take a look at you. To be compliant in the Global Forum, you also have to be compliant at the Financial Action Task Force. As a matter of fact, in January 2015, Trinidad and Tobago underwent the mutual assessment in the third round mutual assessment, and we failed, at our fourth round mutual assessment in January 2015, we failed the Financial Action Task Force. Under this government, we took steps to treat with the Financial Action Task Force. We came out of enhanced follow-up and blacklisting under Financial Action Task Force. We graduated by a succession of steps. We did legislation, we did implementation. that anti-money laundering aspect that is embedded in Financial Action Task Force then came to meet the Global Forum. Now, Madam Speaker, what I found incredible from the member for Barataria San Juan and the member for Siparia was their statement, the joint statement, that the UNC supported every piece of legislation responsible for getting us out of the Global Forum. Madam Speaker, it is a matter of absolute record on the Hansard that the members opposite, led by the member for Siparia, prevaricated on three essential pieces of law: the Income Tax Amendment Act, the Multilateral Convention to deal with assistance in tax matters, and very importantly, the Tax Information Exchange Act, which I'm going to come to, because Barataria San Juan has completely missed the mark on the law today in his submissions on competent authority. Madam Speaker, the Hansard report demonstrates that the opposition dragged us to a joint select committee. In that joint select committee, 2017, 2018, 2019, 2020, Madam Speaker, we had the indignity of the opposition telling us we needed to make critical amendments. The critical amendments, Madam Speaker, and I want to refer to the Hansard report itself. If you look, for instance, to the debate on the Mutual Assistance, Administrative Assistance in Tax Matters Bill 2018 on the 12th of February 2020, you will see, Madam Speaker, at the Hansard at page 70, that there were 8 clauses in the legislation that we were looking at. Those 8 clauses were a cut and paste, 100% cut and paste, for the law that we passed in the FATCA law. It was so incredible that the opposition would not support the law. Then, as Attorney General, I wrote to the member for Siparia, and I set out side by side the 8 clauses, showing that we had passed the same law in the FATCA law, and literally begged the member for Siparia to support the law. There was absolutely no response. When we eventually came out of the committee, Madam Speaker, the members in the opposition said, having delayed us 2016, 17, 18, 19, 20, in the year 2020, as I read from the Hansard, the 12th of February 2020, listen to the landmark amendment that came out of that committee, Madam Speaker. And I'm reading from page 71 of the Hansard. It was that we were supposed to, at page 225 of the report, first column, clause 5, and second column, which shows us the extent of amendments. Here the extent of the amendments. Delete paragraph B and C. And listen to what paragraph B, which was deleted, said. We're deleting the words by inserting after the word that country the words for the receipt and sharing of information relative to such arrangements. And paragraph C, listen to this one, by deleting the words semicolon or and inserting the word semicolon. So, Madam Speaker, we took 2016, 17, 18, 19, and 20, 5 years to effectively delete a semicolon. That is what the opposition dragged this country through in February 2020. It's on the Hansard. All of this talk about landmark legislation support, Madam Speaker, and the contribution of the members opposite, absolute, complete nonsense, Madam Speaker. All that it resulted in was delay after delay after delay. But, Madam Speaker, I want to remind you, that was an opposition that dedicated itself to a promise that they would strike down every single law this government passed. Because as Attorney General, I recommended and the Cabinet accepted that we would pursue law where we could legitimately on the strength of simple majority legislation. We would use the strength provided by Baroness Hale in the Surratt case And Madam Speaker, it was not until the Privy Council reaffirmed its position in Suraj that we got the clear bill of health that we had done everything right. So the member for Siparia raised the concern as to whether in treating with the right to confidentiality to private information today for financial records, we require 3/5 majority. Effectively, that's what the member said. The answer is no, we do not. We are so advised by the Attorney General. We are so advised by the precedents before us. We do not require 3/5 majority because the amendments that we are proposing today are proportionate and, very importantly, they utilize the concept of due process and separation of powers. We are, in the law before us, only treating with access to information, be it at the NIB by a warrant from a magistrate, be it under the Financial Intelligence Unit Act of Trinidad and Tobago by a judge authorizing disclosure on an ex parte basis, be it under the Prevention of Corruption Act, where the DPP must apply to a judge for access to information, be it under the Proceeds of Crime Act. We are squarely utilizing access to information by a judge or judicial officer, Madam Speaker, and not by a Minister of Finance, as the Leader of the Opposition improperly suggested to us this afternoon, Madam Speaker. Now, Madam Speaker, while I'm on that point, and we're dealing with the issue of a minister, the member for Barataria San Juan said they will oppose at all costs the amendments to clauses 13 and clause 15, which propose that the competent authority for the legislation, this is the Tax Information Exchange Act, United States of America, that's clause 13, and the Tax Information Exchange Agreements, that is clause 15. In those laws, as we pass them, we did include then that the Minister of Finance would be substituted by the Board of Inland Revenue. And today the member for Barataria San Juan says that is an improper move to return the Minister of Finance as the competent authority. However, the honourable member got it wrong. The honourable member said we were not amending the USA FATCA agreement, when in fact clause 13 shows that we are, Madam Speaker. If you look to the bill and you look to clause 13, you will see that we are substituting the competent authority as the Board of Inland Revenue and instead utilizing, Madam Speaker, the Minister of Finance. If you look to clause 15, you will see we are doing exactly the same thing for the mutual assistance, for the tax information exchange agreements, for agreements in general. So Barataria San Juan had it wrong. We are substituting Board of Inland Revenue as competent authority for the Minister of Finance in both the FATCA arrangement, United States of America, that's clause 13, and in clause 15 for the general agreements. But Madam Speaker, I want to remind you, when we came to Parliament to do the Tax Information Exchange Act, we came and we requested that we amend the Tax Information Exchange Act and allow for all agreements to be done under one umbrella. It is the opposition that refused to do that, carved out the United States of America and left it alone. But Madam Speaker, the allegation from Barataria San Juan is that no Minister of Finance should be a competent authority, because the honourable member said, what if they want information on the Minister of Finance? And he alluded and suggested that the Minister of Finance would have confidential information of taxpayers. So, Madam Speaker, let us go to the Tax Information Exchange Agreement Act, United States of America. That's Act number 7 of 2017, and 4 of 2017. And let us also go, Madam Speaker, to the relevant law, the Tax Information Exchange Agreements Act, number 5 of 2020. Madam Speaker, the latter act the Tax Information Exchange Agreements Act, which is what we're doing at clause 15 of the bill. The minister defined in the law is the Minister of Finance. Madam Speaker, we are amending competent authority, which is defined in this law as the entity which represents the Minister of Finance, and we are substituting the competent authority listed as the Board of Inland Revenue with the Minister of Finance. But, Madam Speaker, to answer the allegation from Barataria Sanwan, the Minister of Finance still operates within the confines of the law. That is Act number 5 of 2020. And, Madam Speaker, the Minister of Finance has no usurpation of authority from the Board of Inland Revenue. There is a wall legislatively constructed in this Act. The confidential information resides with the Board of Inland Revenue. It does not go to the Minister of Finance. And if the Honourable Member had taken time to read the Tax Information Exchange Agreements Act, the Honourable Member would have seen that. It is the same thing for the United States version, which is the other law that I have referred to. So, Madam Speaker, I reject completely the allegation coming from the Honourable Member for Barataria Sanwan, which the member for Siparia also adopted. Madam Speaker, when we look to what we are proposing today, I want to remind that it is on the Hansard when we were considering what is now Act number 1 of 2024 and Act number 4 of 2024 that Siparia so bitterly complained about. We said on the record, plain as day, that the Global Forum would well require, most probably require, that we amend the very laws that we are passing. And when the member for Siparia complained that we had not proclaimed laws, she made it sound, the Honourable Member made it sound as if we were doing something wrong. We put on the record that we were in active consultation with the Global Forum. We indicated that there was definitely be a move towards amendment of the very laws that we were passing. And Madam Speaker, today we now come to amend a few provisions that are critical to us. In effect, Madam Speaker, we are doing a number of things. We are legislatively completing amendments that are required of us by the inspection of the Global Forum. But, Madam Speaker, if I have your attention, on this particular point, we cannot proclaim some of these laws until the Global Forum has certified that we are in fact compliant with our confidentiality and IT arrangements, and there are certain other prerequisites that they require from an operational standpoint. The good news, Madam Speaker, is that in particular, the Office of the Attorney General, Ministry of Legal Affairs, Board of Inland Revenue, these divisions have gone online. Now today, Madam Speaker, put quite simply, in the Partnership Act, in the Registration of Business Names Act, in the Corporation Sole Act, in the Ministry of Finance Incorporation Act, in the Companies Act, the Global Forum has come up with a new standard for beneficial ownership definition, and we are obliged to now use the definition for beneficial ownership that they have come up with. Madam Speaker, the concept of beneficial ownership only arose in our government when in 2020 and 2019, we piloted the concept of beneficial ownership because we were intent on going to find the money behind corruption. And Madam Speaker, I want to remind you that the members opposite all opposed transparency in beneficial ownership. They opposed the amendments to the Proceeds of Crime Act, the schedule to the Proceeds of Crime Act. They opposed, by their contributions, the Civil Asset Forfeiture Explain Your Wealth Act. They opposed the amendments to the Criminal Division. They opposed the criminal proceedings rules. They opposed the digitization of the judiciary. They went to court led by a fellow named Senator Sturge then, to challenge the laws, Madam Speaker. So contrary to everything that they say, they have done their very best, the members of the opposition, to completely derail all that we do. Madam Speaker, we saw it from Siparia this week. The member for Siparia went to the public to tell the public that the country was given fake vaccines for COVID. Madam Speaker, the leader of the opposition told this country that fake vaccines were administered to people in this country, and the Minister of Health had to object to it and call that out as an unadulterated untruth, Madam Speaker. But Madam Speaker, if the leader of the opposition can say that about vaccines, what do you expect the leader of the opposition to say today about this law to follow the money? Do you expect the leader of the opposition to come and confess to what I have revealed is a consistent pattern of delay and abuse to the laws that we bring? Do you forget, Madam Speaker, that they challenged every single law that we piloted, down to the abolition of child marriage? The leader for the opposition opposed. When we stripped the offending 3/5 majority clauses out of that bill, the leader of the opposition said she would go to court to restore child marriages in this country, Madam Speaker. So, Madam Speaker, can you take the leader of the opposition seriously today to say that the government did nothing, Madam Speaker? Madam Speaker, today we are asking beneficial ownership to be harmonized across all the platforms. Registration of Business Names Act, Partnership Act, Corporation Sole, etc. Number two, Madam Speaker, we are saying, and this is an incredibly important point, we have discovered some time ago, since 2019, and we put to the Global Forum an amendment with features here today, which the other jurisdictions have. That is the amendment to Section 33 of the Companies Act. Section 33 of the Companies Act is the section where you have to record the matters that a company will record. Directors, registered office, etc. We are saying in this law, Madam Speaker, that all companies must, upon incorporation, have a shareholder identified, and that an agreement must be had among shareholders to identify shareholders, those persons who are nominees, and those persons who are beneficial owners. In other words then, if you have somebody pretending to own the share, you need to know. Now, Madam Speaker, why is that relevant? Because that is exactly how you follow the money. Be it a property which was purchased by way of a corrupt contract, owned by a company, with somebody pretending they own the company, but the real owner is a person somewhere else, or be it activities of a criminal nature, the importation of firearms, the importation of drugs, using companies that are defunct or using nominee shareholders. We have discovered by the follow the money process that it is imperative to have shareholders identified. Madam Speaker, today at page A13 of the Express, you will see an advertisement from the Registrar General. I noticed it today when I was reading the papers. In the advertisement from the Registrar General, you will see that public notice is given that you are to look for striking off of your company if you are not up to date on annual returns and other documents, that you will be struck off. But listen to this. You will no longer have to pay $10,000 a page in the newspapers. It's on the website. That attaches to the law that we are amending today, where notice by the Registrar General will be provided. Now, Madam Speaker, the Honorable Attorney General piloted in the last session a very important law in this House, and just a couple of days ago in the last session in the Senate. And that was to allow for the creation of the status of Chief Legal Officer for the Registrar General. Why? Because the Registrar General, under this law and under several other pieces of law, now has the obligation to scrutinize the company's records, to ensure that documents are accurate, to ensure that filings are accurate. But listen to the advertisement today. The Registrar General at paragraph 4 says, an audit of the register as at 31st March 2024 indicates approximately 60,373 companies are in default of the Act for not filing annual returns for 3 or more years. What does that mean, Madam Speaker? This government is paying attention to all corporate filings, all other documents, to ensure that there is transparency, as this bill produces, in requiring nominees to be identified as shareholders, in requiring beneficial owners. But, Madam Speaker, in Section 33 of the Companies Act, which we are amending, Madam Speaker, between clauses 17 and 18, 16, 17 and 18, Madam Speaker, we are ensuring that the owners of companies are identified by their shareholding. Madam Speaker, in this law, you will see that for both external companies and for locally registered companies, we are perfecting, because of the recommendations coming from the Global Forum, the insistence that we deal with bearer share warrants. A bearer share is like a dollar bill. You hand it and it has value. A dollar bill does not say who owns it, it's merely currency. A bearer share is of the same type of nature. It's a share that has value but has no named owner on it. The bearer has the value. We are utilizing the same process we did in the demonetization bill, the Central Bank Miscellaneous Provisions Amendment, providing the same access to court that we did before as to what the methodology for asking for the share to be in your name, instituting the share to its original value, or having it struck off will be. We are using law that has been tested in our judicial system to arrange those purposes. Madam Speaker, very importantly, we are ensuring that we now take care of a few things which we had observed earlier this year. In Act Number 1 and Act Number 4 of 2024, we warned that the Global Forum was asking us to make corporation sole, that's the Minister of Finance, say who the beneficial ownership of corporation sole is. When the law said corporation sole is the person who is the Minister of Finance. And I had joked then that we were being invited to say who was the owner of the person. In other words, then, we went back to chattel slavery. Because we pointed out to the civil lawyers that assess us that an individual cannot be owned and that there's no beneficial ownership of a natural person. You will see that we are treating with that by removing the references to corporation sole, etc., Madam Speaker, and we are now seeing that beneficial owners will also be for international agencies, even if they comprise 2 or more international organizations or countries, Madam Speaker. Madam Speaker, it's important to bear in mind that the process of coming...
Member for San Fernando West, you have 2 minutes of ordinary time left. You're entitled to 15 more minutes to wind up your presentation if you wish to avail yourself of it.
Yes, please.
Please continue.
Madam Speaker, I don't have much more to say. Perhaps I'll end before the full time, but I'll take the full time. Madam Speaker, the process of coming off the blacklist, the description of FATCA on steroids was in fact my language. I said that Global Forum was FATCA on steroids. Madam Speaker, when you look to the laws that we are amending today, many of them show the years that we have amended laws. As Attorney General, you'll see that I amended some laws 13 times in my tenure, 20 times in my tenure. That mere reflection tells you the amount of work this country did and this government did, because to come out of the blacklisting of FATF that the opposition left us in was no easy task. to come out of Global Forum to digitize this country, Madam Speaker, was something that we promised and is part of this law. You look at the Registrar General's provisions in this law. But Madam Speaker, the other side did absolutely nothing about it. But it is a requirement for the Global Forum that our IT is in place. It is our Prime Minister that brought a Minister of Digital Transformation. It was the Office of the Attorney General, when I held that office under this government, that was the first ministry in the Caribbean to go online for payments. We digitized millions of records. We introduced virtual courts. We introduced prison access centers, all operational parts of this bill before us today, all virtually, Madam Speaker. And to come out of Global Forum, we have to take the steps that we are being invited to do, but it is a constant, ongoing interaction. And the Minister of Finance, with the Ministry of Finance, has been doing a significant amount of work. The Registrar General's office in particular, for the last 9 years, has been doing a massive amount of work. The Chief Parliamentary Council, and Madam Speaker, I can tell you, having attended almost all of the meetings up to November last year, even as Minister of Rural Development and Local Government, I attended meetings in Portugal on the Global Forum because the government believes that it must perfect the work that we have started and successfully implemented for 9 years. Today's omnibus package is critically important to this country. The bare submissions of delay coming opposite are disproved by the parliamentary record. The respectfully nonsensical point that the Minister of Finance should not be the competent authority is disproved when they go to the law itself, because there's no access to sensitive personal information from the Ministry of Finance. And Madam Speaker, all that the member for Siparia has to do, if the honourable member wishes, is to perhaps find out who gave her a fake vaccine, because that might be causing the side effects demonstrated in the Parliament today. Perhaps we're not aware of where that came, but maybe that is what the honourable member is facing. Because if it has caused the degree of delusion that I have seen today in the submissions coming from the honourable member for Siparia, that can be the only explanation. This is good work. It is a continuation of work started since 2015, and we will carry the job to conclusion successfully. I thank you, Madam Speaker.
Member for Urupuch West.
Thank you very much, Madam Speaker, for recognizing me so that I could have the opportunity to participate in this very, very, very important debate on the Miscellaneous Provisions Global Forum Bill 2024. Madam Speaker, if nothing else, this bill is testimony to the complete and absolute failure of this government, the complete and absolute failure of the leadership of the member for Diego Martin Northeast as Minister of Finance, who has failed from 2015 to now to actually being able to take this country out of the blacklist that this PNM administration, put us in. Madam Speaker, before I go into the rest of this debate, Madam Speaker, I would want to respond to my friend from San Fernando West. The member joined this debate and went all over the world, traversed all kinds of issues, trying to rewrite history, trying to change the facts as they exist, Madam Speaker. It is a very, very, very difficult thing to do, Madam Speaker, to listen to the former AG. But you know, when I listen to him, when I listen to this member for San Fernando West, I now understand clearly why he is the former AG. I understand now clearly why he was removed from office. Not that the current one is any better, but he definitely, the former AG definitely has something characteristic about him that allows him to speak in a particular manner, believing that in a loud tone of voice he can rewrite history. Madam Speaker, allow me to treat with just a couple of the issues. I noticed that the honourable member has chosen to vacate the chamber rather than listen to facts. Maybe the truth offends many, Madam Speaker. I want to treat maybe just one or two of the issues that he raised, claiming to be rebuttals to points made by members on this side. He spoke about FATCA. He spoke about the minister not having any...
So,
Sorry,
member, I think you...
Yes.
Okay, sure.
The honourable member for San Fernando West spoke about FATCA. He spoke about the honourable member spoke about the Minister of Finance not having direct interaction, etc., etc., etc. Madam Speaker, the fact is that FATCA's, the legislation, and the member is very well aware of this, that the legislation brought to the Parliament, that FATCA legislation, the Tax Information Exchange Agreements, United States of America Act, Madam Speaker, that legislation, Madam Speaker, had initially the minister as competent authority, the Minister of Finance. The current legislation, and the minister is welcome whenever he chooses to return to this debate to serve the country. He is welcome to come in and join us to correct that, to say whether or not the competent authority on FATCA is still the Minister of Finance. Because, Madam Speaker, anybody knowing this current Minister of Finance knows that you cannot associate competent with this Minister of Finance. As a matter of fact, this Minister of Finance has been the most incompetent Minister of Finance that the country has ever known. In fact, if he would only spend time doing his job, this country would not have been in the crisis that we are currently in. If the honourable member for Diego Martin Northeast would only spend time seeking the interests of the population of Trinidad and Tobago, Madam Speaker, if he would only do that, we would not have a situation where our police service, our prison service, our local government bodies, the Ministry of Education, Social Services, etc., those ministries would not have been functioning with inadequate funding. That is the level of incompetence we have from this minister, who seems to believe that he should now be placed as the competent authority in the legislation before us, Mr. Deputy Speaker. And that's the fact. The fact of the matter is that this Minister of Finance is completely incompetent. I want to go back to something that the member for San Fernando West said. The member for San Fernando West started off by saying that we were in a crisis with the Global Forum since 2011. Since 2011. He also said, the honourable member for San Fernando West, also said that Trinidad and Tobago, when they came into office, they found that the situation was so distraught that nothing was being done by the People's Partnership Administration, and therefore this government had to come in to rescue this country and take us off the grey list then, take us off these lists so that the country could have moved forward. Madam Speaker, Mr. Deputy Speaker, allow me to put the facts on the record, which will disprove the attempt by the member for San Fernando West to rewrite history, to change the facts. In 2014, Trinidad and Tobago gave a commitment to the Global Forum through Honourable Minister Larry Howard. The Honourable Leader of the Opposition mentioned this before. And in clear tradition by the member for San Fernando West, he turned it around, ignored the facts, and went in an opposite direction to the truth. Minister Larry Howard gave a commitment when he was Minister of Finance for increased tax transparency and a timeline of 2017. 2017 to put the relevant institutions and organizations and legislation in place. 2017. It is a matter of public record, Mr. Deputy Speaker, and I think the country well knows the mistake they made in 2015 and 2020, because in 2015, this government came into office. And here's what the Minister of Finance is recorded as having said when he took office, the Honourable Minister of Finance. He said, one of the first things, and I'm quoting the Minister of Finance from the 9th of September 2016, he said, one of the first things that I had to do when I was appointed Minister of Finance, when I took up office around the 12th or the 13th of September last year, that would have been 2015, one of the first things he had to do, and I continue to quote, was to write a letter to the Global Forum seeking a one-year extension to a deadline that had been given to Trinidad and Tobago to be compliant with the Global Forum. I indicated, of course, the government had changed. A new government had come in. We needed time to familiarize ourselves with what was happening, and we received that one-year extension to September 2016. Just to marry the two, Mr. Deputy Speaker, in 2014, the Minister of Finance indicated that by 2017, the relevant organizational structures would have been put in place and the legislation to ensure compliance with the Global Forum requirements. Government changed in 2015. The Minister of Finance came in 2015. And in 2015, when he took office, he was fully aware of the requirements for meeting the Global Forum standards. He was very well aware. He has confessed that. He said it here, he said it there. But of course, in typical fashion, the member for San Fernando West, just like the other members on that side, seem to believe that they can wash their hands of their failures by blaming the opposition. You, Mr. Minister of Finance, you members of the PNM, you have been in government and this is going in your 10th year. Absolve yourself of the possibility of blaming everybody else for your sins. Take responsibility. You have been responsible for the last 10 years of spending $500 billion in this country, and every single aspect of life for the average citizen has gotten worse. Mr. Deputy Speaker, there's so much more I could talk about from the contribution from the member opposite that I had the unfortunate misfortune of being forced to listen to. It was filled, it was riddled with misinformation, riddled. It is my hope that at some point in time, the Parliament staff could do a fact check and know for sure some of the citations and recitations that he has raised, attempting to recite and rewrite history. Mr. Deputy Speaker, one more before we go. One more. The member said that a joint select committee, would be the member for San Fernando West, a joint select committee was established and minor changes were done. He said that the joint committee was established in 2016, this is his words, and it collapsed in around 2022. Mr. Deputy Speaker, the Joint Select Committee was established by the government on the 5th of June 2018, not 2016 as the member had said. Further, the Joint Select Committee sat, and I want to say this for the record, the Joint Select Committee sat for a total of 2 hours and 25 minutes from on Wednesday, 6 June 2018. The session lasted 17 minutes. On Tuesday, 21st August 2018, the session lasted 57 minutes. On Wednesday, 29th August 2018, the session lasted 1 hour and 11 minutes. The minister bemoaned the fact that all that Joint Select Committee did was some nominal changes. And he blamed impressively the opposition. He blamed the opposition. This is one minister who was boasting about the failure of a committee that they were in charge of, that they were operating. The minister was boasting about this committee, boasting that the committee failed, provided wrong information about the dates, but boasting that the committee had failed to be able to treat it. Mr. Deputy Speaker, 3 bills were sent, 3 pieces of legislation were sent to the Parliament, not one, 3. 3 were sent to this Joint Select Committee. The government pulled out 1 and brought it for debate. When they brought the rest, I remember, Mr. Deputy Speaker, debate going on and the opposition telling the government that they needed to be. Mr. Deputy Speaker, I'm being disturbed.
Again, Leader of the House, again, you all can just take it down in a little more hushed tone. Yes, thank you.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, the members of the opposition, and that's another point that the members opposite like to claim, that the opposition has not supported this, or has not supported this, or have not supported that. Mr. Deputy Speaker, the opposition has made it very clear, consistently, continuously, that what we will support in this honorable House is good legislation. They are continuing, you know. They are continuing. This is why the country, Mr. Deputy Speaker, is in the state that it is in. Because those responsible for running this country, those members opposite, continue to ignore everything else that is going on. They come here for discussion and for debate. Mr. Deputy Speaker, they say that they come for discussion and debate. The member for Siparia raised it in some level of detail, so I would just mention it in passing, Mr. Deputy Speaker. They say that they come here for debate. They brought here, so they came here and they brought in the minister's presentation, the minister spoke about the amendments that they were proposing to bring. The Honorable Attorney General, in his presentation, he provided details about the amendments that they were proposing to bring. We have an omnibus legislation, 119 odd pages, brought to the Parliament, that we were supposed to spend time to review and analyze, etc. Similar to the ones we had previously, where the member for San Fernando West spoke about it. They brought legislation just like this one and did not proclaim it, bringing it here, occupying Parliament's time, occupying our research time, treating with everything else, and then putting it and sitting it down, and then the minister will boast, the minister of local government, the member for San Fernando West, will boast that, you know, we could not implement, we could not proclaim because changes were still coming. Today we have brought the omnibus legislation and changes are still coming. This is a habit of this government to ambush the opposition. Ambush the opposition, Mr. Deputy Speaker. Because how are we going to now, while we are on our foot, we are on our feet debating a piece of legislation, an omnibus law, an omnibus act brought by the member of finance, the Minister of Finance, and the only people who would have had this piece of legislation, these amendments that he has now brought to the House, the new amendments, the only people who have had that would have been the members on the opposite side. That is unethical conduct by the government, Mr. Deputy Speaker. They alone had the amendments, and they were coming here fully aware of what the amendments were and allowing us to debate blinded without the prior knowledge of this legislation, without the prior knowledge of the new amendments that he's proposing to bring. I want to tie that to what the member for San Fernando West has said. He said, the honorable member that is, said that they could not proclaim the legislation because changes were coming. Today we are doing it again. We are making more changes and more amendments. I wonder whether or not even while we amend the amendments, which are amending other laws, while we amend the amendments of the amendments, I wonder whether or not the government, this government, the Minister of Finance, will at some point in time determine that this is the time let us proclaim. Because we have heard this over and over and over. I could go through the history, Mr. Deputy Speaker. I've had several examples where the very same Minister of Finance came here and said, this is very important legislation. We're going to put everything in place. We're going to meet these deadlines and that. The member for Sama Barataria actually read up a letter in which commitments were given. None were kept. The dates were not. You wrote about 5, honorable member? The fact is, no, I accept what the honourable member is saying. I know that he comes to Parliament with his information. The honourable member, Minister of Finance, says he's written many, many letters with various, and I agree. He's made various commitments to deliver us the relevant legislation to ensure that we come off this blacklist. And to date, we are still not off that blacklist. And to date, we are coming back again. Thank you. We are coming back again with the same promises, the same commitments, and the likelihood, the same results. Mr. Deputy Speaker, for the benefit of those listening, I want to remind this country of exactly what this Global Forum is. Global Forum is about ensuring that countries across the world meet certain criteria for tax compatibility and for tax compliance. Why is that important for Trinidad and Tobago? Because this particular piece of legislation, the Miscellaneous Provisions Global Forum Bill 2024, that's before us today, this particular piece of legislation treats with what the other Act number 1 and Act number 4 would have treated with. This is about it trying to ensure that tax evasion is prohibited. Tax evasion is confronted. And Mr. Deputy Speaker, why is that important? Well, it is important to those of us on this side. It clearly is not important to those members on that side. The members of the government have sat on their hands and facilitated tax evasion, substantial tax evasion by multinational corporations in this country. That is why they have failed, Mr. Deputy Speaker, to implement the relevant laws that Barbados could have implemented, that St. Lucia could have implemented, that Jamaica, other Caribbean countries, and countries way smaller than Trinidad and Tobago could have implemented to ensure that they were global, they were in compliance with the Global Forum recommendations. Smaller countries could do it. Smaller countries could ensure that their regulations prevent and protect their revenue streams, protect their assets, but not this government. Not this government. Mr. Deputy Speaker, it is crystal clear to me, as it must be crystal clear to every citizen listening to this debate.
Again, members, please, on the government bench, again, at least in low tones, or you all are free to exit the chamber and converse. Not a problem. Proceed, or put rest.
Thank you very much, sir. That alone shows you the emphasis that they place on the legislation and the debate that is currently going on before us. Constantly, Mr. Deputy Speaker, this legislation treats with ensuring that tax evasion is confronted, because we can now trade information country to country. This information is therefore critical, and this government would have known about this since 2015 when they came into office. They should have known about it before, because legislation came to this Parliament that would have touched and concerned the current piece of legislation before us. Although it may not have been Global Forum type legislation, it would have been definite financial-based legislation which would have impacted some of the issues being raised here today. Mr. Deputy Speaker, in his presentation, the Minister of Finance boasted about the bill reflecting Trinidad and Tobago's commitment to international tax compliance. The fact of the matter is, Mr. Deputy Speaker, the bill does, in fact, represent the government's commitment to international tax compliance. That is why it has taken them 10 years. That shows what they think is important. The honorable members on the opposite side, 10 years to get here. You are in your 10th year. You are in your 10th year, sir. You are in your 10th year. Thank you very much, sir. Thank you very much, sir. One of the concerns I have, Mr. Deputy Speaker, is the amount of money that would have been lost as opportunity foregone by the failure of this government. The billions, if not hundreds of billions of dollars that would have been lost because this government failed to put legislation in place to prevent tax evasion. We have become a tax haven, yes, hundreds of billions. Mr. Deputy Speaker, we would not know. I am hopeful that the Minister of Finance will tell us what we would have lost by his failure to put this legislation in place over the last 9 years and counting. What would we have lost? Because we know from what was told before us that under the procurement legislation, we know that the failure of the government to implement the procurement legislation cost this country over $2.5 billion per year. We know that the failure of this government to implement the BEPS legislation cost this country over $17 billion per year. We know that this failure of this government to implement this piece of legislation would have cost us further millions and millions and millions of dollars. That is money that could have been brought into this country for the purpose of fixing schools, providing educational services and support, social support, creating jobs, creating a divestment portfolio, creating new revenue streams. That is what this government has cost Trinidad and Tobago by their failure to implement this piece of legislation. But it's not just that, Mr. Deputy Speaker, because the failure of the government to implement the legislation also creates a different situation. You see, there's a penalty. There is a penalty, Mr. Deputy Speaker. Failure to implement has a cost. Failure to implement has a cost. Blacklisting has a cost. Mr. Deputy Speaker, consequences of being on the blacklist, the EU blacklist. One, consequences of being on the EU blacklist. And I'm reading here from a publication by the EU itself. Mr. Deputy Speaker, consequences of being on the blacklist that we have been on since this government has been since this government has been involved in the Global Forum. We have been from 2017 to now on the blacklist, and before that, we were being warned that a list was coming. 2017, we were being warned. Consequences of being on the blacklist. One, blocked access to EU funds. Consequences of being on the blacklist. One, blocked access to EU funds. Two, tax schemes automatically reported. Three, tougher money laundering security. Four, stricter rules for multinational companies. Five, national level penalties. Mr. Deputy Speaker, I could break these down, but what these are disincentives for institutions and businesses who want to come into Trinidad and Tobago to invest. These are major disincentives for investment. It's ironic that the members on the opposite side would jump up and blame the opposition. They continuously rant and rave that the opposition is preventing investors from coming into Trinidad and Tobago. The opposition is this, the opposition is that. We are preventing investors from coming to Trinidad and Tobago, Mr. Deputy Speaker. It is actions like this, the failure of the government to put the relevant machinery in place to ensure compliance with international requirements. Those are the kinds of things that create disincentives to investors wanting to come into Trinidad and Tobago. It is the failure of the government to ensure that the Ministry of National Security is well equipped. The various institutions under the Ministry of National Security, the police service, the prison service, etc., that those are equipped so that we don't have the crime wave we have now. Those are disincentives for investment. This has nothing to do with the opposition, Mr. Deputy Speaker. It has everything to do with the failure of this government to do the job required of it. Instead, what they seek to do is to cast aspersions and blame Kamla. Going into 10 years, you're a very good colleague, going into 10 years, sir. I will not be short-sighted and blind-sighted and short-sighted. Mr. Deputy Speaker, legislation is being brought to treat with beneficial ownership. This Global Forum legislation also treats with beneficial ownership and makes amendments to the amendments that went before with regards to beneficial ownership. In Trinidad and Tobago, we have cast the net very wide. Our net is now 10% of the estimated value of shares. 10%. Mr. Deputy Speaker, everywhere else in the world that I have been able to take a good look at, we are looking at 25%. St. Lucia, that got off the Global Forum listing, 25% or more. The US, not less than 25%. The UK, 25% or more. Jamaica initially had 50%. And in order to become compliant with Global Forum requirements, they dropped it to 25%. Mr. Deputy Speaker, why is that important? That is important because if we are 10% consideration here, and the rest of the world is looking at 25%, we are being placed on an uneven playing field, expecting greater compliance for ours and less compliance for theirs. Mr. Deputy Speaker, I want to recommend that the Honourable Minister of Finance reconsider, even at this stage, that 10% threshold towards a 25% threshold that the rest of the members of Global Forum seem to be inclined to take, except for this very minister. Mr. Deputy Speaker, the Honourable Member for San Fernando West also spoke about interchanging between the minister as the competent authority and the BIR. If at this piece of legislation, my reading of the Global Forum Bill 2024, Miscellaneous Provisions Global Forum Bill 2024, suggests that it is in fact an attempt to amend the legislation to facilitate the minister being the competent authority. The member for San Fernando West shifted it around. The minister being the competent authority. If this is what the Global Forum recommends, Mr. Deputy Speaker, then I challenge the minister in his wind-up. I challenge the minister in his wind-up because we are clear that we cannot trust this government. We cannot trust anything that they say. And in one instance, they say that the right. On the one instance, they say that we are getting off the blacklist, and then we're not getting off the blacklist. On the next instance, they say that they are concerned about money laundering, they are concerned about the tax evasion, and then we still don't put the legislation in place. We cannot believe anything that they are saying. We have heard all of this before.
Member, you just have about 2 more minutes of your initial speaking time. You have an additional 15. You care to avail yourself?
Thank you very much, Mr.
Proceed.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I think citizens of this country are fed up. I think citizens of this country are absolutely fed up, and I think that they should be. We are fed up of hearing the goalpost is changing, and therefore we can't implement legislation. We are fed up of having to come to Parliament to fix bad legislation being brought by the members on the opposite side. But we are fed up, Mr. Deputy Speaker, more than anything else, of hearing and seeing the government put priority on things that are not important to Trinidad and Tobago. Mr. Deputy Speaker, Mr. Deputy Speaker, Mr. Deputy Speaker.
Again, members, I think this is about the 3rd time a device, I think, has gone off for the day. So again, please ensure that your devices are either switched off or on silent, please.
Mr. Deputy Speaker, it seems that whenever the government is called upon to do something for the benefit of the country, they fail. They do not see this as a priority. We looked at the procurement legislation that they got completed in 2015. Procurement legislation in their hands in 2015, something that was designed to prevent corruption, something that was designed to ensure compliance with the law. This government took 7, 8 years, gutted the legislation, then put it in place, and cannot even implement it up to today. And that legislation was designed to treat with corruption. This legislation is designed to treat with tax evasion. This legislation is designed to treat with tax evasion. That's what the whole focus of Global Forum has been since inception. And when they came into 2015, that should have been their focus too. When the Minister of Finance came into office, that should have been his focus too. 9 years, 10, going to 10 years afterwards, this still is not an issue of concern for them. The Minister will come here today and rant and rave and misbehave. He will read out the explanatory notes and claim that the government is doing such a great job. The fact of the matter is that after 9 years, we have heard all of this before. We are not convinced that this government is serious about treating with tax evasion, about preventing tax evasion, just like we are not convinced that this government is concerned and concerned that they should be about the financial losses caused by corruption and the failure to properly implement the procurement legislation. Mr. Deputy Speaker, it seems that the only reason that they are rushing this piece of legislation today as a priority is because the relevant organization is in Trinidad and Tobago and is providing them with some kind of information. Plus, I believe that a peer review is due very soon. A reassessment is due very soon. And maybe they're trying to get into that positive reassessment. The Minister has given a commitment as of December next year. That remains to be seen because, like the Minister himself said, there have been multiplicity of commitments. But blacklisting, Mr. Deputy Speaker, also has an international reputation. This country is not viewed very positively because of this blacklisting. Again, the Minister knows that, and for 9 years sat on his hands and did nothing. I swear, Mr. Deputy Speaker, this has to be the laziest Minister of Finance that this country has ever seen. It is my hope, it is my prayer that at some point in time, the government of Trinidad and Tobago, this current government of Trinidad and Tobago, get up and start treating the interests of Trinidad and Tobago, interests of the people of Trinidad and Tobago as something important, not to be placed on a wait list and a waiting like this one. Mr. Deputy Speaker, I thank you very much for the opportunity.
I call on the Honourable Acting Prime Minister.
Thank you. Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I don't propose to be too long this afternoon, but I thought it important to contribute and to enter into this debate to make a few points. Firstly, we have listened very carefully to those on the other side, and previous speakers on this side have dealt with some of the misinformation that comes and falls from the voices of those on the other side as usual. What was important, though, is that the member for Siparia did indicate the opposition's support for this piece of legislation here today. So I thought it important, Mr. Deputy Speaker, to put in context why this legislation is important and really to defend the actions of this government, because this government has worked astutely and has been working with the Global Forum and the EU to make sure that we're compliant. The first point I'd like to make, Mr. Deputy Speaker, to the population is an understanding of exactly what it is we're here to do today. Because the member for Oropouche West made some remarkable submissions, one of them being about the leakage of billions of dollars of tax by the non-implementation of the legislation that is before us today. Lest the population fall for that misleading submission by the member for Oropouche West, this legislation is to allow EU countries, countries of the European Union and other OECD countries to get access to tax information of companies that may do business in Trinidad and Tobago, or persons who may be situated in Trinidad and Tobago. This is nothing to do with this government's collection of tax on anyone's behalf, or this government's collection of tax for the purposes of Trinidad and Tobago. So I'd like to start by saying, please, that this proposition by those on the other side that there has been leakage by this government, by the non-implementation, is completely false. I listened very carefully to both the Minister of Finance as well as the Attorney General. They've made it abundantly clear that they too were not responsible for the amendments that have only been put before us all, including the members of government, at the sitting this afternoon. So I would like the population to know, as both the Attorney General and the Minister of Finance said, the country has been engaged, our people have been engaged since the 9th of this month, a few days ago, with a team from Global Forum, looking not only at the legislation that is here today, but at other things that need to be done to assist us in getting off the blacklist. And it is last night that these amendments were proposed to the government being a responsible government, immediately brought it to Parliament today. So there is absolutely no fault of the government. The government could have done what I suspect those on the other side would have done if they were in power and they were in government, which is to discard it, as they did, because no matter what the member for Oropouche West says, as the member for San Fernando West said, and it is irrefutable, it was a UNC government that signed up to this body in 2011. It was a UNC government that failed to begin and to initiate what needed to be done, and then made promises that they would get it done, which of course they never fulfilled before the population voted them out of office in 2015, that led to Trinidad and Tobago finding itself in this unenviable position. And I dispose of and condemn this submission that this government would want our country to be in the position it is in today. So the other point I'd like to make to the population, through you, Mr. Deputy Speaker, is the goalposts, unfortunately, do move. The fight against corruption is an evolving one. So what may have been accepted as a beneficial trust in 2011 is no longer accepted now. Every time we engage with the European Union, and I'd like to take the opportunity now to thank them, because they've been particularly useful under the EU High Commissioner Cavendish, working along with the Minister of Finance and the Attorney General. I have been at some of the meetings in trying to assist us in getting done with the legislation what is needed to be done. And we see an example of it. That is where the amendments came from last night to the government of Trinidad and Tobago that have found themselves before us a few hours later today. It is because they are engaged with the government, trying to get us where we need to go. And yes, we will be back, I'm sure, in the future. Because every time you start to plug holes, unfortunately, the corrupt in society globally find other loopholes, and you have to keep amending the law to go after it. But what I would like the population to understand is who are the persons constantly challenging the legislation to fight corruption? Who are the persons that have gone to court to challenge unexplained wealth orders? Who are the persons constantly challenging the constitutionality of law that is clear on the face of it, is to fight corruption? It is those on the other side. Who are the people that are constantly fighting pieces of legislation like bail amendments to fight criminality? It is those on the other side. And I'd like to thank the 5 members who have a conscience on the UNC side, who are obviously now putting pressure on the rest of the bench, because that is one of my propositions today, that the only reason the member for Separia rushed to her feet to declare to the population, and most importantly to the whole UNC bench, that the opposition would be supporting this legislation is because of the very real fear that 5 members on the other side who are now voting with conscience may have embarrassed the rest of the Follow Me bunch. So this legislation, the member for Separia made a most amazing proposition to the population today, talking about this new UK ETA travel requirement. Any child with a smart device and access to the internet can just search it and see immediately this requirement that is coming into place, the ETA requirement, to enter the United Kingdom from the 1st of January 2025 has absolutely nothing to do with the Global Forum. You need only do a Google search. So it is obvious that whoever's attempted to prepare the member for Separia, she should be aware. She should even be fearful. They may be trying to set her up. It has nothing to do with Global Forum. It is actually persons from Canada, persons from the United States are also required to fill this out. And I remind all of those like-minded, civic-minded, sensible people in the population, when it was COVID, to enter the United Kingdom, you had to fill out an electronic form. All this ETA form is a form of border control. Trinidad had implemented something called Travel Pass to enter Trinidad to allow you some element of border control. It has absolutely nothing to do with Global Forum. But what we've seen, and I wanted to draw attention to it once again, is the member for Separia trying to mislead the population. Unacceptable. But an interesting point was made, and I quote, when I was Prime Minister, because you see many people have to banker. It is always when I was this, when I was that. Throwing barbs over onto this side as to where the Prime Minister is, etc. But we have a Prime Minister who works. Yes, yes. We have a Prime Minister who may have traveled a number of times for the people of Trinidad and Tobago. Yes, yes. And today we are seeing the results of his travel. The travel that the Prime Minister, the member for Diego Martin West, has done since becoming Prime Minister for Trinidad and Tobago has resulted in additional billions and billions of dollars for the people of Trinidad and Tobago, in him going and facing down oil and gas companies around the world having conversations with the decision makers around the world. And I guarantee the population, the member for Siparia, and the whole sorry bunch between 2010 and 2015 were unable to do that because they negotiated not a single oil and gas contract. Oh, they negotiated one that continues to cost the country billions of dollars in losses. So it was important to remind, but this is what the member for Siparia said. When I was the Prime Minister, they, meaning the United Kingdom, threatened to introduce visa requirements. And then she went on to say blacklisting has consequences. I'd like the population to know that is absolutely true. When the UNC government was in power, the United Kingdom government did threaten to put visa requirements on the citizens of Trinidad and Tobago. What the member for Siparia stopped short of doing is telling the population why. And I will tell the population why today. It was because, as had become part of how they operated as a government, there was a specific national security unit, a vetted unit in national security, that is a unit that receives intelligence, receives cooperation from other vetted units, including the United Kingdom, in the fight against transnational organized crime. And the United Kingdom government had determined that the Kamla Persad Bissessar government, the Siparia-led government, was interfering with that unit, had stopped the funding of that unit, was putting pressure on a vetted unit to fight transnational organized crime. And I ask them here today, through you, Mr. Deputy Speaker, on behalf of the citizens who are interested, why is it that they did that? Why is it that they did that and that unit started to suddenly become underfunded? Because you see, a lot of the problems we face in our small Twin Island state are as the result of transnational organized crime. And it had to be a threat made to that then government that if you don't put your house in order and make sure that that unit is properly funded and given the proper people to operate the unit, who are subject to vetting and subject to no political interference, we would have all as citizens been subjected to visa requirements. So don't try to tie that type of behavior to the behavior of a government that from day one in office in 2015 has had access to all of the intelligence operators around the world, providing us with the necessary, not us the government, but providing those under the government's umbrella with getting that. Because I also recall there was a time when the US government obviously took a decision not to send an ambassador to Trinidad and Tobago during that period. And today is not the day to say why, but the population can speculate based on what I've just spoken about. So it is wrong for us to sit here and to be subjected to complete misinformation, for us as citizens to continue to be subjected to the type of behavior where they're trying to mislead the population and to suggest anything we're doing here today is less than what is best for Trinidad and Tobago. Because you see, Mr. Deputy Speaker, I can say without a shadow of a doubt that this legislation is evolving legislation. You will always have in the fight against corruption the need to close loopholes. And what you're seeing here today is as a result of the hard work of those involved on this side of the government, along with the experts from the EU and the Global Forum body that we've heard about. This is normal. So to suggest that it is an omnibus piece of legislation and you keep coming to Parliament as though there is something wrong with that, why didn't they come to Parliament in the first place? Why is it that those on the other side continue to put this country in crisis every time they're in the corridors of power? They did it in the energy sector, and then they have the audacity sometimes to try and undermine the hard work that has been done on behalf of the people of Trinidad and Tobago. They have done it right here when it comes to our correspondent banking. I recall the member of that San Fernando West spoke about, the member for Aruka Maloney and I were tasked with meeting with those on the other side, the opposition at the time, when it was FATCA legislation. They put this country in a crisis where we had correspondent banking being threatened to be taken away. And it is only when we in the government explain to the population, understand if the United National Congress opposition does not support that FATCA legislation in 2016, you could not pay for your children's school fees, whether it's at university, remittances to family members abroad and their remittances to Trinidad could not take place. You can't use your credit card on international. And the population came alive to the risk that the country was being put by an irresponsible opposition. And then to sit here and listen to the hypocrisy of the suggestion that, oh, we supported those pieces of legislation. Yes, but under what duress? And it was the same thing with the amendment to the Bail Act. Because not 6 months had passed after they rejected that anti-gang legislation that the population again saw the UNC for exactly what it is. No interest in bettering Trinidad and Tobago, be it in the fight against criminality, be it in the fight against corruption, be it in the promotion of our energy sector, be it in the promotion of our health sector, that we had a leader of an opposition this week suggesting to a population that is still suffering the trauma, the mental trauma of what we faced in COVID, and to tell the population about fake vaccines, and then boom, what surfaces? A photograph of no other than the member for Siparia receiving the same vaccine that saved hundreds of thousands of lives in Trinidad and Tobago. So I congratulate the Minister of Health, the CMO, and all of the medical staff, who I remind the population came under attack several times a week in the courts, in litigation. The poor, $14 million in fees, but the CMO and his team, who were charged with the responsibility of saving the lives of citizens in Trinidad and Tobago, had to be distracted by a UNC opposition taking them to court. They lost every single case.
48-1. I'm listening to the acting Prime Minister. The relevance is not in this bill.
Thank you. Thank you. Members, please. Overrule. Proceed.
Thank you very much. To help my friend from Point up here, the relevance of it is not only to be responding, Mr. Deputy Speaker, to some of the submissions made before, but also to remind the population why the submissions that we've heard made from those on the other side are not only nonsensical, but they're misleading, and quite frankly, they are untrue. One of the most bizarre propositions that I heard made from the other side this afternoon, Mr. Deputy Speaker, is when you have an elected member of Parliament, someone who's put themselves forward to the population asking, because it's a privilege. It is a privilege for the 41 members in this House to be in this House. It is a privilege to put yourself to an electorate and to ask them to put you into office to represent them. That is the belief of the PNM. That has always been the principle of the PNM, because we understand that we're doing service to the population. To hear a member, an elected member of Parliament, say this afternoon, I am fed up of having to come to Parliament to fix bad legislation, has to be one of the most upsetting things I have heard in the 10 years I have been privileged on behalf of the people of Trinidad and Tobago to serve in this House and in the Senate temporarily. Our job is to come to Parliament to fix legislation, because there is absolutely no singular piece of legislation that cannot be tweaked. So to say that you don't want to come, well, then stay home. Don't come to Parliament. Go and deal with your constituents and tell them why you're not coming to Parliament. It wasn't the member for Siparia, it was one of her followers. So, Mr. Deputy Speaker, it is with those few words that I crave your indulgence this afternoon on behalf of the constituency of Port of Spain, North St. Anne's West, to enter this debate, because much of what was said on the other side, I found to be offensive as a citizen of Trinidad and Tobago. And I thought it my duty as an elected member of Parliament to intervene into the debate, to put some very important points onto the record on behalf of the people for Port of Spain North, St. Anne's West. And with those few words, I thank you.
Member for Point of View.
Thank you. Thank you, Deputy Speaker. I didn't plan to join the debate, but I won't be too long. All right? Just to put some context in what we have heard this afternoon, especially from the member for Port of Spain North, St. Anne's West. And I expected him, as the acting Prime Minister, to join the debate to mark the Hansard as the acting Prime Minister. So I'm not perturbed by him joining, because he really said nothing about the bill, Deputy Speaker. Deputy Speaker, as I said, I won't be too long, but what has caused me great concern with this particular omnibus legislation, Deputy Speaker, is the Clause 8 and Clause 13, I think it is, Deputy Speaker. Clause 8 and Clause 13. Yeah, Clause 8 and Clause 13. Where my colleague from San Juan Barataria San Juan had alluded to about the competent authority, the redefining of who is the competent authority. And that's a critical point. I'm hearing the Minister of Finance saying they come back with that again. Okay, sorry, I apologize. The acting Prime Minister then, the acting Prime Minister.
Hold on.
All right?
Again,
and I listened to
Minister
my
of Finance,
colleague.
you will have,
Hold
on. Minister of Finance, you'll have the opportunity shortly, as the member said, to take the floor. Go ahead, man.
Thank you. I apologize, Minister of Finance, if it was new. But I listened to my colleague from San Fernando West. We were in another place in the 11th Parliament dealing with the FATCA piece of legislation at the waterfront where Parliament was held at that point in time. The member for San Fernando West was the Attorney General at the time. And he piloted, I think, I might be wrong, he piloted the FATCA legislation with the Minister of Finance. Or the Minister of Finance piloted the FATCA legislation. And one of the great concerns that the opposition had on that piece of legislation was who was the competent authority. In that original piece of legislation, the Minister of Finance wanted to be known as a competent authority. That was one of the biggest bugbear or stumbling block for the opposition on that piece of legislation. I listened to the member for San Fernando West, and I think it was so long ago he got it wrong today, this afternoon. Because really and truly, that was the issue for the opposition, one of the greatest issues. I remember the past member for Caroni Central, Botewari, was adamant about that, who was the competent authority. And we felt that there should be a separation of duties in the institution, not to have the Minister of Finance, who is a political appointee, be the competent authority. Because it was a 3/5 bill and it needed the opposition vote, we went to a joint select committee and hammered out, and it is there on the record where the Minister of Finance, who was chairing that committee, worked with the opposition on that FATCA piece of legislation and came out with a better piece of legislation for this country, where they also redefined who was the competent authority and making the BIR, the Board of Inland Revenue, their competent authority. We agreed on that. The country agreed on that. The opposition was satisfied with that change, and we voted for that piece of legislation. At that point in time, with that FATCA piece of legislation that we are dealing with here today as an amendment, Deputy Speaker, you know, the chambers came out, the Bankers Association came out, and talked about how the sky will fall because we did not want to support the FATCA piece of legislation. Even from the opposition, we had some of our members who wanted to support that piece of FATCA legislation in its original form. And we had to fight tooth and nail with our members to ensure that this country, with the opposition leader, Member for Separia, come out with a better piece of legislation for this country. And we did. We did, because when we passed that piece of legislation on the 11th session of Parliament, both sides were happy. We had that on Hansard. It is there, Deputy Speaker. So today, to come and look at an omnibus piece of legislation where the Minister of Finance now slips in a change of who is the competent authority. And I have to ask the question, because no one on the government side who has gotten up this afternoon, including the mover of the bill, never explained the rationale for moving the BIR as the competent authority and putting the Minister of Finance as the competent authority. We have a concern. And if it is wrong that the Minister of Finance, because when we were debating that piece of legislation back then, we told the Minister of Finance, it is not about personalizing the Diego Martin Northeast member. We are saying that let us make legislation for the future, because he would not always be the Minister of Finance. So while their members might trust this present Minister of Finance, we don't know who will be the next Minister of Finance. And that was one of the biggest issues we had as an opposition. So to come back here this afternoon, Deputy Speaker, to see the reversal and slipped in, I use the word slipped in, which has no bearing on the global forum issues. So we agree we want to get off the blacklist. And even in the piloting of this bill, the Attorney General and also the Minister of Finance, remember, Diego Martin Northeast, never said up to today, all of these pieces of legislation, we will get out of the blacklist. I remember back in 2017, when the then Attorney General, the member of San Fernando West, would come time and time in Parliament and tell the opposition, we're getting off the blacklist, vote for this piece of legislation, and we'll get off the blacklist. Up to today, 9 years later, we're still on the blacklist. I don't know if that was one of the reasons why he was removed as Attorney General. But this present Attorney General has not fared any better. So we still ask the question after today, and I hope the Minister of Finance in his winding up could give us the comfort that two things. For me, why he wants to change competent authority from BIR back to the Minister of Finance. Why the Minister of Finance wants to have that authority. And secondly, for me, as a member for Pointe-à-Pierre and my constituents, if we pass this piece of legislation here today, if we would get off the blacklist. Because not one of them have said so. I listened to the Attorney General, he used the word a work in progress. And we have been having this work in progress for 9 years. But other CARICOM countries could get off the blacklist, but Trinidad and Tobago seems, under this present government, not to be able to come off the blacklist. So we need some comfort. The country needs some comfort here today. And at least we understand the legislation. There are some amendments to the legislation. We understand that has to impact on global forum. We have no issue with it. But we have an issue with that competent authority definition, Deputy Speaker. So I said I gave my assurance to the Minister of Finance I won't be long. And I am not going to be long, but I want to, at least in his wind-up, clarify my two concerns: competent authority definition and when we will get off the blacklist. I thank you, Deputy Speaker.
I recognize the Minister of Finance.
Thank you, Mr. Deputy Speaker. First, I want to thank the opposition for signaling that they're going to support the legislation. We shall see if that is so when it comes to the vote. But I am thanking the opposition in advance. Now, there has been a lot of misunderstanding, misconception, misstatement, and statements made by members opposite that have no relationship to the facts. Let me deal first with this whole confusion about competent authority. In all ALL of our double taxation treaties, which go back 50 years and still subsist to this day, the competent authority is defined as the Minister of Finance or his authorized representative. That was so throughout the 5 years and 3 months of the UNC government. I don't know, as my honorable colleague from Port of Spain North, St. Anne's West said, whoever wrote that speech for the leader of the opposition, I don't know if it was a setup. But in all our double taxation treaties, the competent authority is the Minister of Finance or his authorized representative. In the 2017 U.S. Tax Information Exchange Agreement, also known as the FACTA Act, even though in the body of the act, of that act, the competent authority is defined as the Board of Inland Revenue, in the agreement with the United States, the competent authority is defined as the Minister of Finance or his designated representative. So that this is just, I don't know what to call it, much ado about absolutely nothing. This is standard practice all over the world. If you go even to Barbados, you will see in their typical legislation, similar legislation, it is the Minister of Finance who is the competent authority or his designated resident. What is this all about? So really, I have to dismiss that concern. It is just of no basis, has no substance whatsoever. If I were to listen to members opposite, if I were to listen to the member for Pointe-a-Pierre, listen to the member for Siparia, listen to the screaming of the member for Barataria, I will have to go and change every single double taxation treaty we have with every country in the world and delete Minister of Finance that has been there for 50 years and replace it with Board of Inland Revenue. Please do your homework. Do your homework before you come here with a big song and dance carrying on about nothing. Absolutely nothing. Hey, all right. Cool it. Now, the other one that bothers me is this question posed by the leader of the opposition about whether the UK ETA is being imposed on Trinidad and Tobago because we are blacklisted by the Global Forum and the EU. What kind of question is that? The member for Port of Spain North has already indicated what the facts are, but let me go further. Let me go further. The UK Electronic Travel Authorization, the UK ETA, is a digital travel permit system. I'm reading from the UK government website that allows the UK government more control and oversight over individuals entering the country. It is part of a broader government initiative to digitalize the borders as it replaces the UK system of visa waivers. The UK ETA is not a visa. It is simply a document for foreigners who do not need a visa to enter the United Kingdom. Now, I'll try and read and spell for members opposite. The UK Electronic Travel Authorization is a travel permit for visitors to the UK who do not need a visa. So every single country that currently does not need a visa to go to the UK, every citizen of every country, will now be required to fill out the electronic travel authorization. Everyone, US, Canada, all of the 27 EU countries from next year will be required to fill out the ETA. Now, how in God's earth could it be that it is because of the blacklist and the EU and the OECD that has caused the UK to impose this restriction on travelers from Trinidad and Tobago? It's illogical. The United States is not on any blacklist. Canada is not on any blacklist. The 27 EU countries can't be on their own blacklist. But every one of them will have to fill out an ETA. Again, I don't know who wrote that speech for the member for Siparia, and I'm beginning to think it was a setup. When we go to the third complaint coming from members opposite, that this legislation will allow police to go into people's house and search. Again, who wrote that speech for the member for Siparia? The existing and current legislative provisions enable police officers to enter and search any premises for financial records on the basis of an order granted by the High Court. This is in the existing Prevention of Corruption Act via Section 9(1), the Proceeds of Crime Act, Section 32, the Anti-Terrorism Act, Section 24, the National Insurance Act, Section 32, and the Financial Intelligence Unit Act, Section 16. It's there. It's already law. The police, after application to a judge, can enter anybody's premises and search for financial records once the judge authorizes them to do that. So why on earth would a member for Siparia say this legislation now allows the police to enter people's homes and search for financial records when it has been there for years? And those are the 3 points made by members opposite, just 3 points. They vex because the Minister of Finance is now suddenly the competent authority for tax purposes, when the Minister of Finance has been the competent authority for 50 years. They vex because they think police could now go into somebody's home and search for financial records when that has been the law for years. And they vex because the UK is going to impose electronic travel authorization restrictions on us as if we are the only country, when it's 89 countries in the world that will be required to comply with that. There's nothing else for me to say, Madam Speaker, except to apologize to members of the opposition for receiving the amendments late. We got them last night, we vetted them today, and we were under the impression that the relevant officer would send them to the Parliament. Apparently, they arrived late. I apologize for that. And with those few words, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Prevention of Corruption Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the National Insurance Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Registration of Business Names Act, the Companies Act, the Tax Information Agreements, United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions, Trustees, Exchequer and Audit, the Minister of Finance Incorporation Act, the Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions, Register General, Companies, Registration of Business Names, and Non-Profit Organizations Act 2024 be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Prevention of Corruption Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the National Insurance Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act,
the Petroleum Taxes Act, the Registration of Businesses Names Act, the Companies Act, the Tax Information Agreements United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions, Trustees, Exchequer and Audit, the Minister of Finance Incorporation Act, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions, Registrar General, Companies, Registration of Business Names, and Non-Profit Organizations Act, 2024.
The Minister of Finance.
Thank you, Madam Speaker. And firstly, I must thank the person who did my procedure, because I don't have to call out that long name. In accordance with Standing Order 68.1, I beg to move that the Miscellaneous Provisions Global Forum Bill 2024 be committed to the Committee of the Whole House to be considered clause by clause.
Honourable members, the question is that the Miscellaneous Provisions Global Forum Bill 2024 be committed to the Committee of the Whole to consider the bill clause by clause. All in favour say aye. Any against? I think the ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. This bill has 18 clauses.
Clauses 1 to 10.
The question is that clauses 1 to 10 stand part of the bill. The question is that clauses 1 to 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 10 now stand part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. Minister of Finance.
Thank you very much, Madam Chairman. An amendment has been circulated. I don't think I need to repeat it. But the purpose of the amendment to Clause 11 is to correct a cross-reference typo. That's the first part of it, Part A in the amendment. And then for the second part, the purpose is to ensure that the register of members contains the full details by including membership interests in the list of required particulars.
Member for Parliamentary San Juan. The question is that clause 11 be amended as circulated. The question is that clause 11 Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is, clause 11 as amended now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 11 as amended now stands part of the bill.
Clause 12.
The question is that clause 12 stand part of the bill. The question is that clause 12 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. Member for Barataria Sanwa.
Thank you very much, Madam Chair. Madam Chair, this was one of the issues I had raised in the debate with respect to the changing of the definition of competent authority. The current definition of competent authority would be the Board of Inland Revenue, and now it would be the Minister of Finance. I just want to ask the Minister, what is the reason for changing it from the Board of Inland Revenue to the Minister? Because this was a contentious point that was raised in 2017 when we were doing FATCA, and we had an agreement from the government that they will change Minister to Board of Inland Revenue, and it seems as though we're reverting to the bill that was laid before the Joint Select Committee agreement. Yes?
Has it?
Yes.
All our double taxation treaties have the Minister of Finance as the competent authority.
Now, the Minister of Finance would be privy to sensitive information.
Not at all.
But in this, if you look at the parent legislation minister, when you see competent authority being utilized at Section 7 of the parent legislation, it means that the minister or the competent authority will be the ones exchanging the information.
No, sir.
So how is it that, because the board has no role again to play, because the board is no longer involved as a competent authority? I'm not hearing you, Minister.
It is the designated representative.
But the competent authority is the one who shares the information.
I have to designate the person doing the sharing. If you go into the parent legislation, you can see I can only give the general directions. But it's the same thing with Clause 4 of the Income Tax Act.
But in this particular circumstance, this deals with only FATCA, no other double taxation treaty, just FATCA we're dealing with here. This particular amendment in Clause 13.
No, but they want all of the double taxation treaties to be harmonious. One of the things I have to do is to sign a treaty that will allow us to enter into standard double taxation treaties with all countries. If we don't do that, we are going to fail in terms of global forum and also the EU blacklist. This is a requirement.
Well, I hear you, and I looked at Barbados, and Barbados is using their revenue authority as a designated authority.
No, sir.
I have the MAP designation. If you look at the MAP designation
Minister of Finance.
No, that's completely incorrect. The website has the Barbados Revenue Authority as a designated authority.
I can't debate this with you. I just looked at it myself 10 minutes ago. It's
I
Minister
have it.
of
I can have
Finance.
the printed copy. I could give it to you.
I have seen it myself. It's Minister of Finance.
I wouldn't trust anything said down with you,
No, and we are very uncomfortable with this particular amendment because
saying
you're reverting to.
This is the global standard. You have to remember we live in a globalized world.
I can't understand why
This
we
is
can't
what
let the
Global
board remain the
Forum
competent
wants.
authority.
This is what the OECD wants. This is what the EU Council of Ministers wants. And if we don't do this, we're going to fail. And I heard a lot of talk, especially from Oropouche West, that we need to do this. So you want us to fail?
Wait, no. Are you saying that?
1 minute. If I could just break the to and fro in. Member for San Fernando West.
Thank you, Madam Speaker. Just for the record, the Tax Information Exchange Agreements Act number 5 of 2020 specifically says at Section 4 that for the purposes of the Act, a state shall undertake through its competent authority. Section 7, which is not being amended, says the board, and the board is defined as the Board of Inland Revenue, has for the purposes of giving effect to a declared agreement all the powers, and then it sets aside. And nothing in this Act, as it's set up, including where information has been exchanged, puts the Minister of Finance in the position of the board only in respect of being the competent authority. So the Act, the Parent Act, disaggregates the Board of Inland Revenue from the competent authority. The competent authority does not receive sensitive information. There's a prohibition by Section 4 of the Income Tax Act against that, and we are not repealing the Income Tax Act in any way, Madam Speaker. I'm just putting this on for the record.
Now, San Fernando West, there's a misconception with that entire argument, because in relation to FATCA, the competent authority is the one who receives the information and sends the information. And then there's a clear section that says that Section 4 of the Income Tax Act is inapplicable if you look at Section 8 of the parent legislation. So San Fernando West's argument is clearly incorrect. At this particular point, we are arguing whether or not the minister gets involved in the sharing of the information. The current setup is that the board is the one who receives and shares the information with the US through FATCA. Now that is going to be designated or given to the minister, and that is where our issue is. And I can't see that the OECD is getting itself involved in FATCA, because they have no issue with this. This is between the Trinidad and Tobago and the United States of America. And that is why we are very uncomfortable with this change of competent authority.
So we could go from
I
14
don't
to
think we need to belabor this point. In all our double taxation treaties, the minister is the competent authority. In Barbados, the minister is the competent authority. In all of the other countries, the minister is the competent authority. The minister is prohibited from accessing personal and private tax information. The minister will not get it. The minister cannot share it. The minister must designate a competent authority, which in this case would be the Board of Management. I don't know why you want to belabor this point.
Okay, so the question is that clause 13 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 now stands part of the bill.
Clauses 14 to 16.
The question is that clauses 14 to 16 stand part of the bill. Member for Barataria.
Madam Speaker, just for time, I am just going to rely on my previous objections that I have raised in relation to clause 13 with respect to clause 15 and 16, because it's the same matter that is being considered.
Let me educate the member for Barataria, who seems to be reading some different law to what is published. I have in my possession, Madam Chairman, a copy of the official gazetted country-by-country reporting tax act of Barbados. I have it in front of me. This was published on the 24th of December 2021. And in this law, section 3 defines the Barbados competent authority for income tax country-by-country reporting as follows. And I shall read from this Barbados Act. Madam Chairman, I think this is important to debunk the bad or misinformation, you could call it what you want. Barbados competent authority. 3.1. For the purposes of this act, the minister responsible for finance is the Barbados competent authority. I don't know what legislation the member for Barataria is reading, but I am reading from the officially gazetted Income Tax Country-by-Country Barbados Reporting Act 2021. So I cannot accept what the member is saying. He's wrong.
Just to respond to that, I have in my hand from the website of the OECD the Mutual Agreement Procedure Profiles, which deals with something called the Mutual Agreements Procedure. So when a requesting state wants to get information from a requested state, they have a list of those persons that you must contact. When you look at the MAPS profile, they have all the countries, and when you click on that, Madam Speaker, it is clear you will see the names of the actual individual who you have to contact, especially Barbados, and it is a member of the Barbados Revenue Authority. In Jamaica, it's someone from the Tax Administrative Office, Madam Speaker. So what the minister is reading there, I don't know what that is, but if he goes in the OECD website, he will see for himself what we're talking about. And for the minister to not know who is the competent authority, clearly now we underscore why we are on this blacklist.
Minister
If he doesn't
of
even know what
Finance.
he's doing, or
Madam
he's
Chairman,
requesting or requesting.
I find this
requesting
is so
information.
sad. Let me read the whole law that is gazetted in Barbados. Barbados Competent Authority. Let me make it clear. This is the English language. Barbados Competent Authority in the Income Tax Country by Country Reporting Act. Let me repeat. Barbados Competent Authority. Section 3.1. For the purposes of this act, the minister responsible for finance is the Barbados Competent Authority. You then go to subsection 2, which is the point I've made repeatedly, and I hope when I make it now, the member for Bataria will retreat. Section 3.2, notwithstanding subsection 1, please listen. The minister may, in writing, delegate any of his powers and functions under this act as the Barbados Competent Authority to the Commissioner. That is exactly what is in ours, that the competent authority is the minister, and the minister shall delegate his functions to another person. When the honourable member read that website and he saw different people, those were people delegated by the respective ministers of finance in all those countries. This is primary school stuff, Madam Chairman. I don't think we can accept his objection.
Madam Speaker.
1 minute, please. Let's have a proper meeting. Member for Barataria Sanwa.
That's a pedestrian argument that the minister is given. And I'm telling you this why, Madam Speaker. It is because there's no power of delegation under our FATCA legislation. There's no explicit power. At the end of the day, it says competent authority, and competent authority does this. That is why we named the BIR as the competent authority when we were doing this in 2018. The minister is going behind his promise from 2018 to now revert to placing himself as the minister in the middle of this entire thing. Where is the power of delegation that he's talking about, similar to what he's reading in the Barbados legislation? Look, when I went to the website, you see the person you're contacting here is Graham Scout, Global Relations Unit, Barbados Revenue Authority, 4th floor, Weymouth, Corporate Center, Roebuck Street, Bridgetown, St. Michael, Barbados, West Indies. And I can give you the person's phone number and email address too, because it's on the website.
Who we contacting here?
Minister of Finance.
For the sake of education, I just read the Barbados Act. It says the law, it says that the competent authority in Barbados is the Minister of Finance or his delegate. All those names you read in there are the delegated people. Throughout the world, the minister, Madam Chairman, I didn't say a word when he was talking.
Well, you mean when the member was talking?
Yeah, when he was talking.
The member was talking.
The member, I'm so sorry, the honourable member.
All right.
So I would ask the honourable member, allow me to speak.
So, in the interest of us managing time well, after the Minister of Finance has made this point, I will let the member for Barataria San or member for Superior respond, and we'll have after that one more contribution on this, then the question will be put.
Right, and they're just making this difficult because they don't want the public to hear. In the gazetted
Madam Speaker.
You see, when we all don't abide by proper decorum, this is exactly what happens. Okay? So if every member will control themselves, which is the only person you can control, we'll have a proper meeting. All right? I can't call out anybody here because on both sides, the behavior is less than what I expect of you all. Minister.
Thank you very much. It is a matter of factual record that in Barbados, which is the country cited by the honourable member for Barataria and Samoa, the competent authority for tax information exchange purposes is the Minister of Finance or his delegate. And therefore, the person's name that he's reading out from Barbados is the delegate of the Minister of Finance. This is so throughout all the countries that are on the OECD website. That person is the delegate of the Minister of Finance. That is why you will see different names. But it is the ministers of finance who are the competent authorities, and they delegate their responsibilities to that individual. I tell you. And now coming to the second point made by the member for Barataria Someone, which is also wrong. In the FACTA legislation, which I have in front of me, it says in this act, competent authority in relation to a tax information exchange agreement means, in the case of Trinidad and Tobago, the minister to whom responsibility for finance is assigned, this is the change we're making, or his authorized representative. The member just said that is not in the act. I have to worry what legislation is the member looking at. Let me read it again. In this act, section 3, competent authority in relation to a tax information exchange agreement means, in the case of Trinidad and Tobago, and we are now amending that, the minister to whom responsibility for finance is assigned, or his authorized representative.
1 minute. 1 minute, please. Minister of Finance, if you could just give us the proper citation of what you're reading so that I can put very quickly into this discussion.
This I am reading an act to make provision for the implementation of agreements between Trinidad and Tobago and other states providing for the exchange of information for the purposes of taxation and for related purposes. And it says in this act, with this amendment, competent authority in relation to a tax information exchange agreement means, in the case of Trinidad and Tobago, the minister to whom responsibility for finance is assigned, or his authorized representative. Or his authorized representative.
Member for San Fernando West.
Madam
and then
Speaker,
I'll take member for Samoa Barataria San Juan.
Madam Speaker, the member for Samoa Barataria alluded to the potential in his reading that we didn't have authorized representative in the law. But let me assist the honourable member. The amendment at section 15, at clause 15, is to delete board as the minister and to insert minister to whom responsibility for finance is assigned, or his. And when you put it in the body of section 3 as it is amended, it specifically leaves authorized representative. So the law will have the Minister of Finance or his authorized representative, bringing it on all fours with the provisions that the member has sought to guide us to. So all that was wrong, or perhaps the only way that the member needed assisting, was to point out to him that the minister in the parent law as is proposed to be amended by clause 15 will also have an authorized representative, putting it exactly on the precedent he seeks to rely.
Member for Superior.
Object strenuously. I don't know why the minister wants to get into people's tax business. Why? We fought this battle in this parliament before. The minister is now telling me section 3 of the law. I don't read that in section 3. I don't know what law the minister is holding up. I believe he's holding up the present bill and reading from the bill, which was what he's trying to do now is to make himself the minister, the competent authority, and be object strenuously. I'm looking at section 13, and that was Act number 4 of 2017, but the present Act here. 13, the Tax Information Exchange Agreements, is amended in sections 5 and 9, deleting competent authority, substituting competent authority means Trinidad and Tobago, the minister whom responsible. That's a bill, madam. That's what the minister is trying to do. That is not our law. And if you want to tell me Barbados has it, which we don't believe because the minister has done the research, Barbados is making it very clear. Barbados Revenue Authority here on the OECD website. We do not agree to this Minister of Finance or any Minister of Finance having access to people's tax exchange information. We do not agree. Say you want to send people into people's homes to pick up financial records and so on, cannot stand for that, will not stand.
Read clause 13 into the record. Because
we just finished clause 13.
So what we on?
I believe we're on 14 to 16.
Well, okay.
We did 14 to 16 as a block.
Member
for Barataria San Juan raised the issue with respect to what he had raised in 13 as the same issue in 14 and 15. So we're not going back. We've already put the question. So we are, 15 and 16, I'm sorry. So we're doing as 14 and 16 as a block. Okay?
No problem.
Yes?
To deal with 15 and 16, the wording is identical. The Minister of Finance or his representative. It's the same thing right through. And what the member for Badarata is alleging wrongly is that the words or his representative don't appear. But they do. It's the minister or his representative.
Okay, so the question is that clauses 14 to 16 stand part of the bill. The question is that clauses 14 to 16. Minister of Finance? Minister of Finance? No. If it's disturbing me, it's not private. The question is that clauses 14 to 16 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 14 to 16 now stand part of the bill.
Clause 17.
The question is that clause 17 stand part of the bill. Minister of Finance.
Everybody's taxing. He wants to know about your business. Don't trust them.
You are the Revenue Authority, and now you want this.
The Revenue Authority is in charge of that, and now you want to take charge of your tax.
Correct.
We do not trust you.
He say how you could designate somebody. When the envelope reaches
But why
the
don't you
desk.
designate home?
Correct.
We are amending
Look at the IR now.
clause 17.
It is now, and he's taking it out and putting it in.
Put in himself. Oh, sorry.
Could you take off your mic, please? Thank you. Minister of Finance.
Yes, we believe that the term Registrar General should be placed in the interpretation section rather than the other part of the Act. Basically, that's it. And then, with respect to the next part of Clause 17, a shortfall identified by experts is the need to have all trusts, constructive, implied trusts, whatever, registered under the trustees' ordinance. This is required to, this part was inserted to provide the registration requirements for trust instruments. Clause 17 is quite long, so that in other parts of the Clause 17, there are some typos that we are correcting. Express trust. Okay. Any difficulty with this? Good.
The question is that clause 17 be amended as circulated. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 17 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 17 as amended now stand part of the bill.
Clause 18.
Question is that clause 18 stand part of the bill. Minister of Finance.
In the amendments to clause 18, the fee is actually a monthly fee and not an annual fee, so we had to change that. And the current framework prescribes the following process has been flagged as too onerous and could result in the possibility of companies inadvertently reporting their beneficial ownership, so that the clause has been refined to make it less onerous for persons to comply. Any issues with 18?
Member for Parliamentary San Juan. Okay. So that the question is that clause 18 be amended as circulated. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 18 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 18 as amended now stand part of the bill. Honourable members, the question is the bill as amended be now reported to the House. Those in favor say aye. Those against say no. I think the ayes have it. This committee meeting is adjourned. The House will resume. The Minister of Finance.
Madam Speaker, I wish to report that the Miscellaneous Provisions Global Forum Bill 2024 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Miscellaneous Provisions Global Forum Bill 2024. All in favour say aye. Aye. Any against? I think the ayes have it. Minister of Finance.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Prevention of Corruption Act, Proceeds of Crime Act, Anti-Terrorism Act, National Insurance Act, Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Registration of Business Names Act, the Companies Act, the Tax Information Agreements United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions Trustees, Executor and Audit, the Minister of Finance and Corporation Act, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations, and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions Registrar General Companies, Registration of Business Names and Non-Profit Organizations Act, 2024, be now read a third time and passed.
Honourable members, the question is a bill entitled An Act to Amend the Prevention of Corruption Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the National Insurance Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Registration of Business Names Act, the Companies Act, the Tax Information Agreements United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions Trustees, Exchequer and Audit, the Minister of Finance Incorporation Act, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions, Registrar General, Companies, Registration of Business Names, and Non-Profit Organizations Act 2024 be now read a third time and passed. All in favour say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Prevention of Corruption Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the National Insurance Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Registration of Business Names Act, the Companies Act, the Tax Information Agreements United States of America Act, the Non-Profit Organization Act, the Tax Information Exchange Agreements Act, the Mutual Administrative Assistance in Tax Matters Act, the Miscellaneous Provisions Trustees, Exchequer and Audit, the Minister of Finance Incorporation Act, Income Tax, Companies, Partnerships, Securities, Tax Information Exchange Agreements, the Non-Profit Organizations and Mutual Administrative Assistance in Tax Matters Act, and the Miscellaneous Provisions Registrar General Companies, Registration of Business Names and Non-Profit Organizations Act 2024.
The Leader of the House.
Speaker, Madam Speaker, I beg to move that the House do now adjourn to a date to be fixed.
Honourable members, the question is that this House do now adjourn to a date to be fixed. All in favour say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to a date to be fixed.